2, 1.
Good morning, everybody, and welcome to the Board of Oil, Gas, and Mining's June 24th, 2026 hearing at the Department of Natural Resources. We have an interesting agenda today, so we're going to start with our briefing session, and there are 5 parts to the briefing session. Now at the end of the briefing session, we typically have an opportunity for public comment. I've been made aware that there are parties here that want to make comments on particular docket items. So rather than have public comment at the end of the briefing session on the various dockets that might be 15 or 20 minutes or maybe an hour later, let's consider reserving our public comment until that docket item comes up. But you're always free during the public comment period to go ahead and make comments anyhow. So with that, Mr. Thomas, time's yours.
Thank you, Board, and thank you, Chairman and members of the Board. My name is Mick Thomas. I'm the Director for Oil, Gas, and Mining for the state of Utah. I have just a few items I'd like to bring to your attention. Last week, I participated as a board member remotely, or pardon me, in person in Michigan at the Board of Directors meeting in Traverse City. The Groundwater Protection Council is a nonprofit organization similar to the IOGCC or the IMCC that comes together to develop and support member states with technical training at cost. As they also offer some industry advocation, specifically around groundwater. They go beyond oil and gas. A significant number of their member states are also state division of environmental quality and other things like that. So anyhow, we came together as a board member to discuss strategy for the GWPC. Most of the pertinent conversations revolved the migration of how we're developing our data systems from basically a hard drive system to more of an AI, real-time, kind of intuitive system. We've seen that across multiple industries and even in our daily life as we use artificial intelligence more and more. And the reason we discuss this is GWPC supports and has developed a oil and gas data management system called Risk-Based Data Management System, coincidentally, or RBDMS, that member states use to manage their oil and gas data. We talked about how to best modernize that to meet the needs of member states, and it was a productive conversation. Any questions on that? Again, happy to discuss offline or at this meeting. There's my intro. If you got any questions for that, we'll move to the next topic.
How's California found their experience so far with RBDMS?
California representative was not there at the meeting. Sorry about that. I do have some, sort of related information. I know that they spent a significant amount of money 6 or 7 years ago trying to develop something. Ultimately, it was either not successful or they chose to go a different direction. That's what I know now, but California was unable to participate this past week. Thank you, Chairman.
Okay, thank you.
Okay, thank you. Next topic, we're going to ask our rules coordinator, Natasha Baliff, to update us on brine rulemaking. Natasha?
Thank you. I'm Natasha Baliff. I'm the legislative and planning coordinator for the division. Just a quick update on our brine rules. We have completed our internal draft and we're ready for stakeholder engagement. So this is more of just a notification that we're going to move forward with that. Just as a background, in 2024, House Bill 433, which was sponsored by Representative Bolender, the bill urged us to do a study on brine rulemaking, see if it's needed. And then we came back in 2025 with House Bill 478, and we put the Brine Conservation Act in place. During this study, we had a list of stakeholders. And just some of the agencies included were CITLA, Division of Water Rights, Division of Forestry, Fire, and State Lands, Utah Geological Survey, Division of Water Quality over in DEQ, the Bureau of Land Management, we were working with people out of the Moab Field office. We had a handful of division employees. There were a few legislative representatives, and then we had a few additional stakeholders. So we're going to use that same stakeholder list that helped us with the study, along with a handful of other people who've expressed interest just in general in our rulemaking. So yeah, this was just notification that we're moving forward. If you have any questions, I'm happy to do my best to answer them.
So are we going to enter what you would consider an informal rulemaking process at this point?
Yes, so this would be informal. This will be going back and forth with stakeholders, discussing the language, the content of the bill, which was something that we took from the statute, and then kind of used our oil and gas rules and some of our mining rules to create this overall rule for brine.
Okay, great.
So are you ready to circulate that draft
Yes.
now? It's
Yep.
going out in the near future?
Yes, so in the near future, we'll send it to the list of stakeholders, make sure everyone is still interested. We'll schedule a stakeholder discussion. We can start talking about the bill, reviewing it, making sure everyone is in general agreement around it.
Thank you.
Yeah.
Okay, cool.
And so what do you think the timeline is on it as far as going through the stakeholders and having a draft,
I would love it to be under a year. It kind of depends on how much pushback we get from stakeholders. Sometimes there's a lot, sometimes there's not a lot. So we might have a better idea after the first 1 or 2 meetings with stakeholders. But this one hopefully is something we wrap up fairly quickly.
Okay. That's actually a pretty good segue into our next speaker. So,
It is.
anything else, Mr. Thomas?
On that topic, no, I would ask that Natasha hang around for just a moment. We have some other topics to discuss.
Okay.
Thank you. Next item on the agenda, a geothermal energy update from the state engineer, Teresa Wilhelmsen. I opened this table flip for her. As she and her team are walking up, this is actually a very special guest regarding the amount of expertise she has, and we appreciate her time this morning. For that, I'd like for Teresa and Jim to take over. Thank you.
Yeah. Absolutely.
Thank you.
Okay. Yeah. Okay.
Okay. I'll talk into the mic here. So first of all, thanks for the invitation to come present to the board. Really appreciate it. So Teresa Wilhelmsen, I'm the Utah State Engineer and Director of the Division of Water Rights. And I'm going to have Jim introduce himself really quickly as well.
I'm Jim Goddard. I'm the Geothermal Program Manager for the Division of Water Rights, State Engineer's Office.
Okay. So what I'm going to talk about first is just what the State Engineer's Office is and why we have geothermal as part of our program. And then also kind of what are the makeup of our office and agency and the qualifications that we have. So let me jump in, and then we also are prepared to answer a lot of questions regarding the FERVO incident that just occurred as well. So the State Engineer's Office was established in 1897. It's probably one of the oldest state agencies that in Utah. It was moved, or the Office of the State Engineer was moved into the Division of Water Rights under the Department of Natural Resources in the 60s. So the Office of the State Engineer is housed in the Division of Water Rights. I am appointed by the governor and confirmed by the Senate for a 4-year term. I'm actually in my 2nd term of state engineer. And the main responsibilities of the state engineer is the general administrative supervision of the waters of the state. We appropriate them, we apportion them, we deliver it, we manage it, and various activities that associate or touch that water space fall under the jurisdiction of the state engineer. So just a really quick evolution of state water law. You saw in 1847 the pioneers came. Utah became a state in 1896, and the state engineer's office was created 1 year later. I'm the 20th state engineer to serve the state of Utah, and in 1903 is when the first water code was put in place that applied to surface waters. Then in 1935, code was put into place to manage groundwater. So those two authorities are under the state engineer. And one thing to really highlight here, I think that's important to understand, throughout the western states, various different laws apply within the states, whether it's water or oil and gas or, you know, a variety of things change. One of the things as part of my duties as I serve as part of the Association of Western State Engineers, and when we talk about conjunctive management of surface and groundwater within the state of Utah, many states are very surprised that we've been regulating groundwater since 1935. So it gives us a leg up, in my opinion, over some of these other Western states who really just started regulating groundwater in the last 10 years. And now they're trying to play catch up. But we have a long record of groundwater rights within the state of Utah that we have to manage conjunctively. So let me just talk quickly here about our division structure and leadership. So I lead the division, and I have 2 deputies that serve. All 3 of us are licensed professional engineers. Under Mike Drake, we have our 7 regional offices across the state. Each one of those house a regional engineer that has authorities to carry out daily activities, and all of those regional engineers are licensed within the state of Utah. I'm going to focus on Blake here a minute. Blake is my deputy that oversees our 6 functional sections. And so within his chain of supervision, you find our geothermal and groundwater program, which is Jim Goddard. I'm going to highlight some of the activities that we do and the authorities of the state engineer, and I'm going to focus on these 6 functional sections. Kind of going down that line there just below Blake, we have our applications and records, and within that section, I'm just going to highlight our title program. We oversee title to water rights, which is like real property, and we work very closely with county recorders on understanding surface and mineral estates and how we update water rights in particular, the title to water rights. In kind of going down to the third one, dam safety and stream alteration. The state engineer, since statehood, has been responsible for the safety of the dams in the state. We inspect over 300 high hazard dams. We don't inspect federally owned dams, but state and privately owned dams. So we have a group of engineers that work on the safety of the dams within the state of Utah. So we're very familiar with being able to do emergency response. Whether, you know, we have to put in place on all of these dams annually, we make sure that the emergency action plans are updated and current with current contact information, because when you need it, and you never know when you need it. One example I maybe could highlight, if for those of you that may have heard about the Penguich Dam that was nearly failed about a year and a half ago. That was our division that responded to that, to get on site, assess what the damage was, work with the owner, work with their engineers to come up with a solution so the dam didn't completely fail and be catastrophic to the community of Penguich. So dam safety, we take throughout the division, you know, the protection of life and property very seriously, and have for many years to do that. Stream alteration is another one of those programs that I'll just highlight. We actually have a joint permit with the Corps of Engineers where we work very closely with them. We can issue state stream alteration permits very quickly. The Corps, through that coordination with the Corps, we're able to do that. Now, the Corps will still assert jurisdiction over wetlands and other projects that may affect wetland areas, but we work very closely. We just renewed that permit again last year for another 5 years in working with them. Under that stream alteration program, I'll just highlight, we also have emergency authorities for flooding. When you think about flooding happens, effects to these communities, who is then regulating what can happen in those stream corridors, or what emergency actions can we issue? So we have those emergency powers for flooding. It also relates to drought, which we're in right now, some severe drought, which are causing some serious impacts to communities. 2 cities just came up with emergency actions that need to occur because their wells have gone dry. So we're working with those communities to do that. So let me just jump down to technical services, and this is where Jim Goddard is in this section. We oversee groundwater, so groundwater management plans. If groundwater aquifers exceed safe yield, we have to regulate those water rights and the water that's being diverted. Conjunctive management, his team helps us understand some of those connectivity between surface and groundwater. We also have the well drilling program. This is licensing of all of the state's water well drillers that are out there drilling the water. Jim and his team oversee that program and inspect those wells as they're being drilled, and even for compliance to current rule. And then geothermal is also in this program. And I'll talk a little bit more about geothermal, but let me just highlight throughout the division, we have on staff almost just over 36 licensed engineers that go through continuing education to maintain our licenses. We have 6 licensed geologists. One sitting next to me is actually licensed in Utah, Idaho, and Wyoming. And he did serve on the Utah State University board for the geology department for many years. He's not currently on that advisory committee, but he served on that committee for quite some time. So we also have another 24 engineers in training that will be getting their licenses here in the next 2 to 4 years. And then we have a series of hydrologic scientists that have a variety of education and skill set. The division is ran with about 150 employees across the state. And we're literally turning head gates in a lot of places as well. So we span the entire state with a lot of folks. So let me just jump into geothermal. This is just a segue slide. It looked kind of cool. But anyway, so geothermal. Geothermal statute was originally, the Geothermal Act was created in 1981. And it was given to the the authority under the state engineer. And I really do believe a lot of this came from all of the experience that the state engineer had in responding to life and safety of life and property through the dam safety program, the flooding, drought, and all of those. But it also, I think, is very key when you look at kind of the history of the development of geothermal. A lot of it was hot springs, right? In the beginning, that was the technology that was available. Now it has advanced and has grown into these other technologies as well. But when you think about those hot springs, pioneers had been here since 1847, and water rights were established in a lot of those hot springs. So when this Geothermal Act came about, we needed to make that connection of those existing rights so that we can protect them for those water rights that were established through the process that there's to be established, and then grow that program or grow that industry with protecting that. We also, and I'm going to highlight here, rulemaking. We did just have a bill that went through statute, and I have some slides in here, but I'm not going to go into detail, but I wanted you to have the slides. We will be going through some rulemaking here, and we do have, like Natasha even described, interested parties, and I think it would be great to have someone from the Division of Oil, Gas, and Mining participate as well as we're going through that update to our rules for geothermal. Let's just talk about, here's just some of the code. You have direct use. This is some of the traditional geothermal that have water rights. And it really, the ownership of that is tied to water rights. And that was a discussion in this last legislative session that Senator McKell, when he ran that bill, understood that we needed to keep that ownership with the water right holder, because that's the shallow hot springs and shallow hot water in groundwater. Heating and cooling these open loop systems, we issue those quite frequently. Electricity generation, that's, something that's coming along and really growing. We do require water rights, and I just want to kind of highlight here, and maybe I'm going to use Fervo just as an example. We have in the processes within the state engineer's office, we have the water right process where we ensure that any water diverted has a right and is protecting those existing rights in that same resource. We also have, excuse me, what's called a non-production application process, and we can typically approve those within 30 days. So in these projects like Fervo, they have a combination of those two permitting processes. Through the water right process, we also have the ability under the order of the state engineer to require a groundwater management or a groundwater monitoring plan. And that helps us understand and ensure that all of the surrounding communities are involved. It's a public, transparent process. All of the water right owners are known. We protect any of the springs, other wells that are maybe in the same area, but it gives us that opportunity to be able to do those groundwater monitor plans. And we're actively working with Fervo and other entities in that valley on that groundwater management plan. So let me, these are just a few slides that highlight geothermal activity, and I really just am including these last slides so that you have this information of what has gone on with geothermal resources. And then also how we are, and I'm going really quickly here, going through this rulemaking process, and I can go back to that. The rulemaking process that we're going to be going through with the recent statute change that was made through Senate Bill 21 through this last session. And let me just highlight that process. The department and the governor's office and the legislative folks basically were studying and looking at geothermal over the last 18 months as to where it is, how it works. Do we need to make some modifications to the confidentiality? We did lower the temperature because of some technologies that allow for electricity generation at lower temperatures now. So we worked with Senator McKell very closely and others over the last 18 months just to look at the program, and the result is the bill that just passed. And we're implementing that now, and it is felt that geothermal is in that right place because we need to protect the water resources of the state as well. And we also have, expressed by some of the industry folks that they're in Utah for a reason. I associate with the Nevada State Engineer's Office, and they do ask, how do you guys do this quickly? It takes us a year and a half. And I think because of the processes and the experience and the professionalism that we have in the division, that we can attract geothermal to the state of Utah. And I think we do that well. So with that, I'm going to turn it over to Jim so that he can address the Fervo and maybe some questions that you have there.
Okay, before we go to Fervo board, do we have any questions of state engineer?
I'd just say just one comment. I think it was a great introduction because knowing that you have hydrogeologists and such, I think that's very informative.
Go ahead.
Yes, I had one question. So the dam safety program, does that include tailings dams, industrial tailings dams?
Yes, so one of the dams that we inspect annually is Kennecott, actually.
Okay, thank you.
On one of your slides, I saw you went through them really fast, but there was a reference to 248 degrees F. What was that slide?
Let's go back. And Jim could probably.
Okay.
Oh, yep.
Oh, greater than 248. Okay.
Yep.
Got it.
Okay.
Thank you.
Which area would produced water from oil and gas wells come into your purview?
Sure. So that is possibly a whole topic in itself. But produced water, I think it was 3 years ago, just went through a statutory regulation change. If produced water is used for any consumptive use, then it does require a water right. And that might be the simplest way to describe it without going into the whole process about produced water. But happy to address that at a later time or offline with you.
Thank you.
Okay.
And I got one other question. In oil and gas, we go through a primacy procedure on Class 2 and Class 6 wells, and we just finished that up on carbon sequestration, or finishing that up. And that's with the EPA. So do you have to do a similar thing with BLM or DOE or someone like that, like to have primacy on the programs you're talking about?
No. So the Utah Constitution and state statute says that the waters of the state are owned by the public. So I think it's a different, if you want to call it primacy, but the states have control of the waters within their state.
Mm-hmm. But subsurface aquifers can go across state lines. How do you deal with that stuff?
Yeah,
'Cause
and
we
they
have
do.
oil and gas that goes across state lines too.
Yep. And when you think about it, surface waters, right? So we participate. I actually serve as the Bear River Commissioner because it goes across 3 states. Colorado River, I just finished meetings on the Colorado River for 7 states that do that. So as far as groundwater, that is typically regulated. There is kind of this false state line boundary. But for example, Nevada, we've coordinated because there are groundwater aquifers that do span those state lines. Each of the states do take jurisdiction over where the points of diversion are, where those wells are within their state. But we do coordinate.
Okay. Which could have, what we call correlative right issues across the boundary and stuff.
Could.
Where they could steal our water, we could steal theirs. Okay. Thank you. Go ahead, Jim.
Yes, I may be able to add to that question a little bit too. I think maybe you were asking also about injection wells and who has primacy over regulating injection wells.
Yeah, well, DOGM has that over Class 2 and Class 6 wells, but
Right.
But we don't deal with the other classes of injection.
Right. So in Utah, the Division of Water Quality has primacy over Class 5 wells, and geothermal injection wells are considered a Class 5 injection well. So, but they have primacy, but we basically have entered into a memo of understanding with the Division of Water Quality to where we actually regulate those injection wells, just specifically geothermal injection wells. So we do the permitting, the UIC permitting for injection wells as well. Division of Water Quality is still involved. They're part of their Class 5 inventory, and that information is submitted to them, and they review that. But in terms of actually permitting those, we do that in-house at the Division of Water Rights.
Okay. And did they go through the process of getting that primacy from EPA?
The Division of Water Quality has, yes.
Okay, good, thank you. Okay.
Great. Well, I'll continue on and talk about one of the issues that was discussed last month, and that's the incident at Fervo with the uncontrolled discharge. So I have a bunch of notes, and I'm going to try to stick to those just to make sure I don't deviate from that. There's a lot of detail in this that I think you'll appreciate on that. So on Monday, May 25th at approximately 4:25 a.m., the Frisco 6 IB well experienced an unintended fluid discharge while undergoing standard well completion operations. Well 6 IB is an EGS injection well with a measured depth of just over 15,000 feet and a total vertical depth of just over 9,200 feet. It's located entirely on Bureau of Land Management land, both subsurface and surface. As per protocol and permit requirements, Fervo immediately notified applicable regulatory agencies, including Water Rights and the BLM. An ongoing status of the blowout was communicated. Fervo immediately notified the Division of Water Rights via text and phone and followed up with that with a written notice early the next day on May 26th. Fervo continued to update Water Rights throughout the incident. Water Rights and BLM officials also inspected the site during the incident. The primary operational scope being conducted at the time was a typical composite frac plug drill-out sequence. Upon completion of the drill-out, the tubing was being tripped out of the well. Shortly after starting the trip process, and while 311 joints of tubing on the work string remained in the well, an audible pop was heard from the drill rig 4, and the work string exhibited an upward movement. The audible pop and upward movement of the work string occurred after pulling 145 joints, and while 311 joints of tubing on the work string remained in the well. Shortly after, a high-rate fluid discharge was observed at surface coming from the tubing at approximately 10 feet above the rig deck. Attempts were immediately taken to stop the discharge, including an unsuccessful attempt to stab the joint with a full opening safety valve, and also injecting 230 barrels of 11.4 pounds per gallon brine into the closed pipe rams to attempt to top kill the well, which was unsuccessful. The work string tubing parted apparently at a relatively shallow depth of about 450 feet. This caused the pressure in the well to short circuit up the tubing, allowing discharge of water and steam at a rate of about 1.5 barrels per minute. The tubing was equipped with a foot valve at the bottom hole assembly, as well as intermediate sub-check valves, which would have otherwise controlled the pressure and flow inside and up the tubing. Discharge fluid was primarily water that was injected under pressure into the engineered reservoir during stimulation activities. The formation would naturally consist of hot, dry, granitoid rocks with no intrinsic, potentially dangerous pressurized hydrothermal fluids present in this engineered reservoir. Moreover, there were no hydrocarbons or dangerous gases associated with this incident. Most of this water flashed to steam at the surface and evaporated, and the water that did reach the ground was contained on site. The water was non-hazardous and did not pose a threat to the environment. Fervo tested the discharge water to verify this. They conducted several remediation points on the ground when this occurred, including developing an excavated sump to collect the water that was flowing from the discharge, and then temporarily pump that water into the reserve pit on site, which it did contain that water. They also opened a number of EGS wells that were adjacent to this well in order to try to reduce pressure on the pressurized reservoir at that process, which was successful to an extent. It didn't completely shut it off to that extent. And they also circulated cool water, cold water, continuously pumped through the kill port on the well to maintain lower surface well temperatures and to cool off the BOP stack that was on site. There were no injuries or environmental damage associated with this incident. Immediate activation of safety and environmental protection protocols were implemented. The crew on site was well trained in well control. Given the nature of the injected water and pressure in the EGS reservoir, over time the discharge water would have dissipated and diminished as the reservoir pressurized, and they estimate it would have taken about 2 weeks to depressurize that reservoir. Of course, they didn't wait that long. They wanted to get it fixed immediately. So that was never an option, to just let the pressure dissipate. CUD Well Control, which is a Texas-based well control operation, was called in almost immediately and was on site to help close in the well and stop the discharge. On Friday, May 29th, and with favorable wind conditions and well control equipment moved to the site, the tubing above the BOP was successfully cut and a shut-off valve installed. After the valve was installed, kill weight brine was injected into the well below the BOP stack to halt pressure in the well and to bring into the tubing and valve. Once the discharge was stopped and the well under control, the workover rig was removed from the well, and a special hydraulic completions unit rig was moved onto the well to remove the tubing above the break and fish out the remaining tubing below the break. The tubing was successfully fished and removed with a completion date of June 4th, 2026. The well is currently back on schedule to be equipped and included in the Cape Station Phase 1 operations. Upon inspection of the damaged tubing, it was determined that the break occurred just below the joint box in the drill pipe. The joint did not fail in this case. The drill tubing was inspected a week prior to the incident and passed. The broken tubing sections are currently being evaluated in a lab to determine the cause of failure. The dropped tubing will no longer be used at the site and has been shipped off-site. It is important to note that a BOP stack was installed and operational on this well during the completion work. When the incident occurred, the BOP was actuated, resulting in deployment of the pipe ram and the annular BOP. This effectively controlled any discharge from coming from the well itself, limiting the discharge to the tubing string. The BOP was also equipped with the blind ram, but did not actuate since the drill string was inside of the BOP. The BOP stack was not equipped with a shear ram, which could have sheared off the tubing when the discharge occurred, thus avoiding the uncontrolled flow out of the tubing. Going forward, the primary corrective action will include equipping all completion work on wells with a BOP stack that includes a shear ram. The BOP stacks used when drilling and well construction already include shear rams. It is important to note that no damage occurred to the well at surface or downhole, and no surface equipment was damaged. The only noted damage occurred with the tubing breaking apart, which caused the incident. A root cause analysis is being conducted at the direction of BLM regulators because the incident occurred on BLM land. BLM is leading out on this and has organized the RCA. BLM has notified water rights has not notified water rights as to who is conducting the RCA. It is still ongoing, and the report will be submitted to the BLM and to the Division of Water Rights when complete. The uncontrolled discharge incident is expected to have little impact on the project's implementation schedule, and Fervo continues progress towards activating their Phase 1 power project by the end of the year. So that's a quick summary. I'd be happy to have any questions.
That's a very detailed summary. Thank you very much for that. Appreciate that. I got a couple of questions, and then maybe the board will have some questions. Did we have enough secondary containment around there to keep the fluids from going off-site, or how's the secondary containment set up?
Sure, the entire pad is enclosed with a berm, so it would have had to fill up that berm enclosure in order to.
Happen.
It didn't happen. No, they maintained those berms. They did within the pad. They created a temporary pit in order to kind of coalesce that water into that pit, and then put pumps in there to pump it to the reserve pit, which was already existing on site.
Okay, good. And okay, some parts you referenced that there was tubing. Some parts you referenced that it was drill pipe that was in the well. What can you help me understand exactly?
Yeah, I apologize for that. It's really the same thing. It's the
okay. They were using tubing to drill the.
Yes.
Okay. Okay. Thank you. Are you putting shear rams on all the other wells? You went really fast through there.
Yeah, so as far as the main drill rigs, the drilling and construction of the primary producers and injectors, those BOP stacks already had shear rams on them. It's only when they were doing the completion work, like stimulation and drilling out the frac plugs, that they did not have the shear ram on that BOP stack. So that's the corrective action going forward is for all the completion work, they would now have a shear ram or some kind of double containment, which is really a shear ram.
Yeah. Okay. Well, I've seen that before, so okay. Thanks. Okay, and on the root cause analysis, I want to be really. Having been through 3 blowouts and a bunch of root cause analysis myself, don't want to be directive here, but I want to suggest that you work very closely with BLM to ensure that there's a real third party that conducts that root cause analysis. Obviously, you can't do it, MIC can't do it, BLM should not do it, and Fervo should not do it. It needs to be a third party so that we get, this is a big deal because it's the first enhanced geothermal system blowout in North America. We need to know not just what happened mechanically, but did we have all the other stuff in place, like the training and all that stuff that needs to be done. And a thorough root cause analysis is needed by a good, competent party. Thanks.
Thanks. We'll follow up on that.
Yeah. Okay. Board members, questions? Yes, someone.
You had mentioned that Fervo had conducted testing to make sure that there was no environmental hazard or anything to the water. Was there an independent assessment of that, or was it just on Fervo's testing that word that there was no environmental hazard, danger, or anything like that?
I don't know exactly how that played out, but I guess I would assume that Fervo collected those samples and had them analyzed at a certified lab.
Okay.
And the information, you know, as you presented it, that came from state inspectors or from the people on the rig, you know, as far as the chronology that you just went through?
Right. It's a combination of receiving information from notices from Fervo when it happened and from being on site and inspecting what happened. So yeah, it's a mixture of both of those.
Okay.
Okay. How did they get that secondary rig so fast? Was it on site or?
It was not on site. They had it moved in, which is why it didn't.
Wow.
Why it took a little bit to. I mentioned June 4th is when they finally completed the fishing operations and got that out. But yeah, they had to bring that in from elsewhere.
Okay. That's impressive. They can do that fast. Okay. Go ahead, Greg.
More of a just curious question. The size of the hole, you know, like the tubing and such, how big was the, you know, the casing and such?
Of the well or of the tubing?
Well, of the well.
So the well, I can give you that information. So the top had 90 feet of 20-inch casing cemented in, 13 3/8 inch casing down to 1,380 feet cemented and tested, 10 3/4 inch casing to 8,733 feet, and 7-inch production casing to bottom of hole at 15,065 feet. And as far as, I don't know 100%, but I do believe that the tubing or the drill pipe was 3.5 inch.
Okay. That all makes sense. Okay. Anybody have anything else? Okay. Thank you so very much. Yes, go ahead.
Just maybe to conclude, just want to make sure that those listening in and the board and even the division, everything that the state engineer does is public facing, transparent. We do have all this information on a website, not all of what Jim talked about, but the geothermal, we have a website for that. We do have some information we compiled into like a brief handout that will also be available on our website, just for those of you that touch that energy space to be aware of what those projects are. And I would just offer, if it would be helpful to the board, we could like annually maybe give an update on the geothermal efforts if you would like that. I just want to offer that out to consider, for you guys to consider. So, but thanks again for having us.
So maybe we'll ask you back next summer, but unless something else comes up sooner. Okay. Thank you very much. Appreciate your time and your thorough analysis and information. Mr. Thomas, anything else?
Yeah, thank you, Teresa and Jim. And I'd also like to follow up with that a little bit. Teresa provided a good segue into this. The board, you know, sometimes you all have questions that are very relevant to other DNR divisions. Water rights is a shining example just now, but also the Utah Geological Survey, forestry, fire, and state lands, even trust lands. And if topics come up, please communicate those to us in real time, and we will endeavor to get representatives from those organizations and those agencies in front of you, because what you just saw was a shining example of, well, having the technical experts and the administrative experts here to answer those in real time. So thank you for that, and I again appreciate
something to add to that, like Director Wilhelmsen said, you know, I've always been curious about the produced water, and she said, oh, that's a whole, you know, a whole nother topic, which is interesting.
I would say that I am not trying to speak for the state engineer, but I would say neither one of us want to really talk about produced water in real time before the board right now. But it is something that we are coordinating with them to make sure that if it's a consumptive use, definitely it falls underneath the water right. And if it's not, then it's not. But we're happy to discuss that at a later date. Thank you. I do not have any other topics for item number 4. Next month's agenda, next meeting is going to be July 22nd here. We have a number of docket items already slated for that. and that'll be Wednesday, July 22nd. And at this point, I think you mentioned you're going to have public comment after each individual docket, but that's all I have to say right now. Thank you, Chairman and members of the board.
Thank you, Director Thomas. Okay, so now we do have an opportunity for any kind of public comment. If people want to make general comments, you're very welcome to do that. Do know that we are going to cover a docket. We have 4 other docket items here, and if your comments are specific to that docket, it's your option. You can make your comments now, or you can wait until after the cases have been presented. So, anyone for public comment? Come on, sir. As you're coming up, if you could please state your name and your association.
I've got voice problems a little bit. My name is Dwayne Morley Cox. My wife is Jeannie Cox. She is a mineral right holder in the basin in about 18 parcels out there, so we watch it. The family has a number of people who are involved. We know that the taxes you raise from the oil production is vital to lots of the things that go on in the state, especially education. Mm-hmm. But we've run into a little bit of a problem that we don't understand. And I'm going to reference a specific well, which is well number Rocket 68 1413-23K. This is a horizontal well, and I've attended these meetings from when we used to drill only verticals down to the horizontal, and now we're getting very long horizontals, and we've never seen what we have seen this last year from a tax standpoint. So it works like this. That particular well was drilled by XCL, I believe, and was in production as early as as early as tax year 25, before SM Energy bought them out. In 24, before Energy, they were bought out and taken over the second quarter of 25. The well was a highly productive well, and the only taxes that we saw, now I'm only going to talk about the oil, but not the other elements, because it's the biggest payoff that members of the family get from their mineral rights. But for 2024, the only taxes that were paid on the oil, and I've never worried about the taxes because it was just kind of a simple thing, but they collected AV taxes, which were the the only taxes really that they collected during the time that they operated the well. But when SM Energy took it over, and I have 4 more copies of this to leave with the board or with SM people who are here. But on the first month that SM took over, we got a tax that we had I thought we'd never seen. I look back and it had been very minor on a couple of wells that Axia or XCL had drilled. And it was, for the first time we really saw a big number, it was for Ute Indian taxes, and it amounts to 10% of my wife's royalties for each month in going forward from there, reaching a high of 14%, 15%. We've never seen that. Early on, I sent a letter to contact SM and ask them, where did this tax suddenly come from? Because Axia had never charged us really anything, and neither could XCL. And so I got a response back that didn't answer the question. So we were in the dark. So I waited until the database I'm talking about was my wife got her check stub back up for 10/28/2025. So now we've got about 9 months experience. And in that time period, we got additional taxes which showed up, and the code is CN. And Axia and XCL had never charged us CN on that well, and I think probably on other wells for the oil portion. Does show up for other product that comes from the well, but not on the oil. It was minor, fairly minor. Then in the 5th month of 25, we got an additional tax added on that we'd never seen before, which is the SV tax. So, and it was in the amount, let me just put the numbers on the table because they're fairly significant. In that month, the product volume from that well was 19,000 plus barrels for a value of $884,000 plus dollars. The taxes that were charged and for which she paid her share were $39,000 for SV and $78,000 total for the tribal ones. The AV was only $3,980, and the CN was $1,769. So what we're seeing at that time is we're seeing deductions of 15% higher than we had ever seen on anything. And so what I'm here today to ask is that I'd like to keep probing it because I'm kind of the go-to guy for the family. I'm willing to come to your meetings, and I've been coming for a number of years, and people have always been good to help. I'd like to have a contact so that I can understand, did the taxes from the state suddenly go up from almost nothing to 5%? Or so I'd like to have somebody that I can talk to within the division who understands the tax, and we'd really like to know what the tribal tax is, what's the basis for it that suddenly has showed up. I figured that for my wife, she lost about $1,000 worth of royalties to these taxes in 2025, and we have one family member whose estate hasn't been divided yet because she's still doing really great, but she probably lost $4,000 worth of royalties. And we've heard from other family members the concern that they're not getting paid what they used to feel like they got paid. And so I'm kind of, I think, the go-to guy. I would just appreciate having some contacts, and I think Julie knows how to get a hold of me. If not, I'll give her all my contact information, but we'd like to pursue it to understand what's going on. So I thank you for the opportunity. Questions?
Well, I don't think we have any questions right now, but just so you're clear, the board is going to rule on technical things and not generally get involved in commercial, contractual disputes.
Understand that, but still, you people must know what the tax law is for this. I don't know where to go to get the tax law on oil, gas products, except through the organization that's here.
Okay. No, we have a general understanding of taxes, but that is not specifically what the board does.
I understand.
What I would suggest that you do, because it sounds like it's a substantial amount of money that you have a question about, is that you get a competent counsel or attorney to take up the civil issues if you can't resolve them with SM. Now I see Mr. Mayo over here antsy to come up, and if you're antsy to come up and address this, Mr. Mayo, certainly would invite you to do so at this point in time. Now, just so you know, Mr. Mayo is an attorney that represents SM Energy and other parties. So he can't represent you or help you.
I understand.
But maybe Mr. Mayo can enlighten you a little bit.
Well, and we don't need to take the time. We could go to the site to do it, whatever you people would like to do. I just came hoping I could find somebody in oil, gas, and mining, not necessarily the board, but from the entity that has the data. I mean,
Yeah. Generally, the board doesn't deal with that, and I don't think
understand
the
that.
division has limited resources to do that. These are things that are civil and dealt with contractually because you have a contract with whoever the operator is there,
Right,
and
right.
not with the board and stuff. But they do have some. But looks like we have a small army of attorneys here that are more than willing to address this with you. And let's start with, do you want to take this offline, guys?
Yeah, this is public comment. I appreciate what Mr. Mitch Mayo, Lear and Lear. I typically represent SM, and I'm here in public comment response on behalf of SM. I understand this to be essentially a soft accounting request. I'm confused about what I'm getting. Can you help me clarify that I've been paid appropriately? For what it's worth, we'll treat it that way from this point forward and just start coordinating with Mr. Cox. If he's unsatisfied with the process, I'll explain to him how to make it a formal royalty accounting request before this board, and it'll be brought back.
Oh.
But if that's okay with you, I'll reach out to you, and we can kind of set up how you and I can start sorting this out.
that's absolutely fine.
Mr.
Perfect.
Chicken?
I'm happy to, I'm a little uncomfortable in the role because I know what he's talking about. This is not necessarily yet I know that they have the records for what all the production has been and everything else. And if you're to study because my wife's rights are in section 24, and this particular oil well draws from 23 and 24, and it draws it such that all of the Ute Indian rights are in 23 and hers are in 24, and she has no property that would deserve an assessment from a Ute tribe, but maybe it's associated with where it's being drawn up out of the ground on the pad. So I'm just looking for help because you may not have the information. I have zero as of today. But when I asked the question of SM, why are we being charged, I did not get an answer, and that's why I'm here today. So I appreciate your time and patience, and I'm happy to go offline and work it. I'm retired.
Perfect. I'm not, but I've got time to do this.
Good,
Yeah.
good.
Okay.
So go ahead. Did you have something too you wanted to add?
This is Rick Harris. I'm the regional land manager for SM Energy, so I just was going to say we'd be happy to work with them and make sure that we can line item and make sure the costs are accounted for appropriately.
And Mr. Cox, rest assured, you're not alone in this. I have to deal with this at home because my wife is a royalty owner and she has lots of questions. And so it's nothing simple about it, and it takes some experts and people, there are attorneys to help you out if it's.
Well, I understand that because I've been coming, but I got a whole family. It's just not my wife. There's others here today who are in the family. We've even heard from family members in California who we've never heard from before who are expressing similar concerns. So, but I'm the fall guy for them, and I appreciate any help we can get. Thank you.
Okay, thank you. Thank you, gentlemen. Thank you, Mr. Cox, and we really appreciate your comments.
Thank you.
It's always great to hear from the public. Okay. Anything else, Mr. Oh, yes. Well, it looks like we have another public comment.
Thank you. We're going to leave.
Okey doke. Thank you. Thanks for coming in. Well, take a minute.
We have another civil matter.
Sure it wasn't stopping sliding. Okay, was a little embarrassing.
No,
Those
that's
chairs
quite all right.
Like that back
Um,
there.
Okay, could you please state your name and your relationship and
So,
what cause you're talking about?
My name is Shelley Lehman. My father, Thomas Burgess, had mineral rights. He's deceased. I got a packet from Crescent. I guess I had mineral rights, so me and my brothers need to see what we need to do to move forward to claim our mineral rights, since my father's deceased.
Okay.
So,
All right. Again, this is a matter of probate.
is it? Okay.
And so.
How do I go
if
about
it's-
doing that? And
Yeah, well, again, our suggestion would be, this isn't something that the division generally has, their attorneys are working on technical matters and stuff like that. It would be suggested that you get an attorney that's familiar with probate and mineral rights that would help you. And Mr. Chicken's here, if he wants to jump in and talk about Crescent's interests there, or give her any kind of counsel that you could for free at this point.
Brent Chicken, Steptoe and Johnson, for Crescent Uinta. Our whole team, land, geology, and engineering. Oh, here comes Mr. Brooks. He'll be happy to talk to you about this.
Okay.
This is creating a record chain of title from the deceased party to their heirs and devisees. And I would certainly recommend engaging an attorney to help you with that process, because it requires filing probate documents with a court and having that judge, identify the heirs and devisees. But Mr. Brooks can talk to you about that to help you, move the ball forward there.
Absolutely. And we can offline. Let me walk you through kind of the steps and the processes. And before I think we get to the probate point, I'm not an attorney, I won't give you advice that way. But let's do a couple checks to determine some things before we set out, saying go to probate and,
Right.
but I'll walk you all through that.
Okay. Okay.
And I'll give you my card and all that.
And
Thank you.
Ms. Lehman, just again, I'm dealing with the same thing with my wife, trying to figure out probate. It's very common, and you need expert advice to do that. Don't talk to your cousin about it or anything like that. So
Okay.
get some good advice.
Thank you.
Hire an attorney, if it's worth it.
Worth
Yeah,
it.
yeah.
Hmm.
That would be the first thing, is to figure out if it's worth a couple $1,000. So.
Easy hands.
Thank you, gentlemen. Appreciate it.
Thank you.
Sorry about that.
Thank you.
Okay, is there any other public comment at this point in time? Okay, I think let's take the first couple items from the agenda. Yes, Mr. Thomas. Sorry.
Pardon me, Chairman, thank you for your discretion. I would like to share that these sorts of questions that you've seen just in the past, comments and questions, it is very common for the Oil and Gas and Mining Division in Utah, and honestly any other state, to be the receiver for these questions, because the public obviously, or understandably, is going to say, I've got a question, who do I call? Personally, my first call is never to an attorney, because there's a certain amount there, and so I appreciate that. We at the division, you are correct, we want to support you. We do not cover royalties, individual royalty disputes or confusion. We are the tax commission has access to a lot of information that even the division doesn't, especially regarding tribal tax rates. I guess what I'm saying is, about a week and a half ago, we drafted internally a policy and process to address these sorts of questions, not only for the public, but also for the division, because people call the field staff, people call the front office. Patty Rowe takes an amazing breadth of questions at any given time. And so we are drafting a process and a policy, not only for our internal use, but also to be posted online, so folks can know where to go, rather than, they're always welcome to come here before the board, obviously, but there's a certain amount of energy that goes into that, and we want to provide better instruction and support for these issues as they come along. So we'll have that up and running definitely by the end of July, if not sooner. I just wanted to add that for you, Chairman and members of the board. And that's all I have to say now. Thank you.
Let's see. And I think one of the things, let's try to make that as plain language as you possibly can. Because, the first speaker, Mr. Cox, he's switching back and forth between royalties and taxes and
Right.
royalties and taxes, and I wasn't sure. And I'm the chairman of the board, and what he was talking about at the time. So we need to make sure there's a clear understanding and it's plain language.
Certainly, I appreciate that. Thank you.
Okay. Are there any other public comments? If not, we'll take on agenda item number 1, which is docket number 2026-029, cause number 997-07, in the matter of formal rulemaking to adopt oil and gas bonding amendments. Take appearances.
Oops, yeah. Sure.
Thank you. Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining. You'd like me
Mr.
to
Haynes?
proceed?
Go ahead.
Thank you. Members of the board, the division is here today to request the board adopt the proposed amendments to R649, which are related to the oil and gas bonding amendments, and also to order the division to set a notice of effective date of July 8th, 2026 for these amendments. This action is being taken by the division before the board to comply with Utah Administrative Rulemaking Act, which is under Utah Code Section 63G-3. It is noted that a copy of all of the amendments to the rule are attached as Exhibit 1 to the Notice of Agency Action. As you are aware, we've had many discussions related to this rule, and it's been a big part of the hearings over the past year. I will now turn over some time to Natasha Bailiff, the division's legislative and planning coordinator. She's going to give a brief presentation related to the proposed amendments.
Hi, thank you. Natasha Bailiff, legislative and planning coordinator for the division. I have a pretty quick presentation for you. I'm not going to get into any of the content of the rule. I think we've done that plenty over the last year. Since 2019, really. So I'm just going to kind of go over the timeline. This rulemaking was initiated from a performance audit of the oil and gas program. Within that audit, the auditor said bond amounts and bond structures for oil and gas wells were last updated 16 years ago. Again, that was 2019 that was said. Which is concerning given ongoing industry technological advances. Insufficient bond amounts and bond structures pose financial risk to the state. Existing bond amounts and bond structures are inadequate. So beginning in 2020, we started to internally draft a new set of rules for bonding. We distributed that draft in September of 2022. We identified stakeholders and then invited them to review the proposed draft. In between September 2022 and September 2024, we held 8 different stakeholder meetings, and those also included a couple board members. We had Steve Church and Levon Garrison attend those meetings as well. And then in 2025 is when we started bringing presentations to the board. So to go over that just a little bit, I guess I didn't need to advance my slide just yet. But it was February of 2025 when our oil and gas staff gave presentations on the current draft that we had. In April 2025, we had presentations by all of the stakeholders, and that included Utah Petroleum Association, Robert L. Bayless, Coda Resources, Scout Energy Partners, Greylock Energy, the Environmental Defense Fund, and additional comments given by National Fuels Corporations and the Trust Lands Administration. In 2026, we began our formal process. We kicked off the year with a 45-day public comment period. That went from January 1st until February 13th. We had another 45-day public comment in March 15th to April 30th. And that also included a public hearing given or held on March 25th. So we've had an incredibly robust process, both internally and publicly, also including the board, which is a little outside of our standard rulemaking process. And then just to reiterate, we will be asking for an effective date today, and the earliest possible date that we can give to the Office of Administrative Rules is July 8th of 2026. One quick last mention, part of the comment or part of the public comments that we received, I have displaying, and on the, the right side, we have responses from the board on the comments that were received. So these specifically were from the March to April public comment period, but we do have all public comments received and the reply on division and board replies to them on the board website. But that is it, unless you guys have any questions.
I'd just like to comment that this has been in the making for 7 years, which is an abnormally long time for a bond,
Yes.
For a rule. And I would like to compliment the division and the public for their participation in this project. I don't know, during the discussions that went on, I don't know how many times I've heard, we've never done this before. We've never done it this way before. And the stakeholder engagement, I think, has been great, and you should all be complimented on the work you've put in over these past 7 years.
Yes, thank you. It has been a massive undertaking for everyone involved.
It's good to bring it to a conclusion.
Yes.
Your mic is muted, Mr. Chair.
Sorry. Mr. Haynes, just a procedural thing.
Sure.
On the Exhibit 1 that I have before me here, in R 649-13-10, it has an effective date of June 1, 2026.
Yeah.
Do we want to verbally amend that exhibit and proffer it for consideration?
That has actually been updated. That was part of an administrative process on the back end, so that should be updated to July 8th, I believe.
Okay, it's just the exhibit I have in my book.
Yeah, and we can, if that's the effective date that we end up having, we can amend the exhibit to reflect the actual effective date that we have today.
Yeah.
Okay, let's keep that amended then to July 8th, 2026 as the effective date. Okay. And before we go into whether or not we're going to deliberate, are there any comments by the public at this point in time? Do we have any online comments?
We do not, Mr. Chair.
Okay, so Mr. Haynes, you want to go ahead and make your closing comments then?
Yeah, they're really brief. As I indicated, the division now requests that the board adopt the proposed amendments to R 649 related to oil and gas bonding and order the division to set a notice of effective date of July 8th, 2026.
So noted. Okay. And Exhibit 1 is amended to, or the proper Exhibit 1 be submitted that has July 8th, 2026 as the effective date.
Yes, we will submit that.
Board, do we want to have a deliberation? Okay, Ms. Garrison and Mr. Church, want to give you a lot of thanks for your assistance on getting this to where it is. So we'll entertain a motion.
I move that the division adopt the rules as proposed for 649 bonding with an effective date of July 8, 2026. And thank you for everything that you've done.
Second?
I'll second that, and I again thank the division also.
Okay, it's been moved and seconded that we adopt the rules with an amended effective date of July 8th, 2026. All those in favor say aye.
Aye.
Any opposed, say nay. It's unanimous. Thank you very much.
Thank you.
Let's do one more before we take a break, okay? Thank you, Mr. Thomas. Thank you, Mr. Haynes. We're going to go on to agenda item number 3. Whoops. I'm sorry, agenda item number 2. Let me get my paperwork. Here we go.
I don't think so.
I don't think so. Ask Natasha if she
Yeah.
needs anything from us. She would know best. You can
Yeah.
ask her later.
Okay, so we're going to go on with agenda item number 2, docket number 2026-026, cause number 379-05, in the matter of request for agency action of Utah Brine Corporation, LLC, for an order vesting ownership in the Big Indian Unit 1, API 43-037-16219, and the Lisbon B912, API 43-037-15769, oil and gas wells. So we'll take appearances.
Good morning, Mr. Chairman and members of the board. My name is Justin Rammel. I represent Utah Brine Corporation.
Okay. For the division?
Assistant Attorney General Andrew Haynes on the behalf of the Division of Oil, Gas, and Mining.
Thank you, Mr. Haynes. Okay. Mr. Rommel, go ahead.
Yes, sir. We might need a moment to fix exhibits.
Okay.
We'll do that after the opening statement.
Okay.
Again, good morning. My name is Justin Rammel, and I represent Utah Brine Corporation. With me is Darren Townsend, who's the COO of Utah Brine Corporation, and he's come to this hearing from Perth, Australia, which I think is probably the farthest possible point on the globe from Salt Lake City. And we hope that sets a board record. This opening statement is just going to be a brief overview of the facts and exhibits that we plan to introduce and a quick summary of the request that we're making. We're asking that the board not vest ownership, but rather operatorship in the 2 aforementioned wells that are outlined in the request. The current owner of these wells is American Helium, as noted in the BLM records and as reflected in the San Juan County Recorder's Office. My client, Utah Brine Corporation, has entered into a deal with American Helium to produce these wells. We'll talk more about that. And American Helium supports their bid for operatorship. They've submitted the requisite materials for recognition by the division, but lack the transfer, the permission of the current operator, Mandrake, to assume that operatorship. Mandrake received rights to this well through Paradox Resources. Paradox Resources is the prior owner. The board's probably very familiar with this oil and gas field in San Juan County. There are numerous shut-in wells in that area. These are governed by the Bureau of Land Management and subject to federal oil and gas leases. Through our research in the bankruptcy petition of Paradox, which was filed in 2023, we don't find any mention of Mandrake. We don't find any record of their ownership in the BLM records of the Recorder's Office. We've reached out to Mandrake and requested that transfer. They've not responded. We filed this board action as a way to gain operatorship from the current owner and have not had any response from them. There's no filing in the record, and I don't believe that they are appearing in this case. So I guess we had assumed this would be a fairly simple procedure. We'd be able to proceed essentially by default, yet the Division of Oil, Gas, and Mining has filed a response where they question the board's ability to designate an operator. We believe that the jurisdiction and authority of the board to designate an operator at any time in the life of the well is very clearly made in both statute and the regulation. We feel that the division is overreading a time limitation on APD protest periods and making it apply to circumstances where it's not appropriate. We'll respond to the division's arguments in due course, and that is the conclusion of our opening statement.
Okay. Do the division opening statement?
You can ask him if he wants to give his opening now or reserve
Yeah.
it for later.
Okay, Mr. Haynes, do you want to do your opening statement now?
Should we unplug and plug back in, maybe?
Oops. Do you want to do your opening statement now or reserve that for after they've presented their case in chief?
Yeah, sure. We can do an opening statement. That's completely
Okay.
fine. Just so the board understands, the division's here because, as by rule, the division is a party to all actions before the board. The division received this RAA and looked at the request. Per the division's understanding of the rules, the designation of operator rule is set up so that an operator can be designated for a well at the time an APD is approved before a well is constructed. Once that well has been constructed and has gone into production, the way an operator changes under our rules is through a change of operator form that is submitted under R649-3. With this request, the division was unable to see any documentation indicating that this party, the petitioner, owns an interest in the wells they're seeking to become operator for, nor have we received any confirmation from the operator of record, Mandrake, that we have in the system. So based on that, the division looked at this request, felt like it was not brought in the proper manner, and we filed our response indicating how we felt that should be handled. Thank you.
Okay, thank you. Okay, we'll come back to you, Mr. Rammel. Then you could go ahead and present your case. And are you going to have a witness to swear in or anything?
Yes, Mr. Chairman, I've got Darren Townsend here who will testify on behalf of Utah Brine Corporation.
Okay, Mr. Townsend, you want to raise your right hand? Do you swear that the evidence you're about to produce or produce for the board is the truth, whole truth, nothing but the truth, so help you God?
I do.
Thank you. Okay, go ahead and proceed, Mr. Rammel.
Apologize for the awkward display here, but I think if we've got it live, then we'll just go with it. Mr. Townsend, can you spell your name for the record, please?
Townssend and Darren for my first name.
And can you provide the board with a personal introduction?
Yes, Chairman and members of the board, lovely to meet you all, and thank you for the time this morning to be present in front of you. My name's Darren Townsend. I'm a mining engineer by background. I've got a long history operating in the mining and lithium space. Worked for a company, Neo Metals, who has a 51% interest in the Utah Brine Corporation, which we're here today representing. I'm also the Chief Operating Officer in that entity as well, and pleased to be here to talk about the opportunity that brine presents down there in the Paradox.
Can you explain a little bit about the Paradox Basin resources and what excites you about the potential down there?
Yeah, sure. I mean, you've got some world-class potassium grades down there, so there's a lot of opportunity. The lithium grades are not as good as the potassium grades, but there's also some potential for some lithium there as well. And our key focus is on looking at opportunity to develop that field into being a producing asset. The company's got a long history in mining. We built and then operated with a couple of partners the Mount Marion lithium mine in Western Australia, which was a hard rock lithium asset.
one of the, probably at the time it was built, in the top 3 or 4 lithium mines in the world. We also do a lot of work on lithium brines for a number of customers. With one of our technologies, we're working with Rio Tinto down in South America, looking at their brines. We've pilot planted their processing, some of their brines we've piloted through our process. So we've got a deep operating history in this space and really see a great opportunity there in the basin. The potassium grades are really world class, and it's been a real surprise to us that it hasn't been sort of further developed. The US, as you're probably well aware, is more than 90% of its imports for potash and potassium come from outside the US. So getting some more resilience inside the US, I think, is a great opportunity. So yeah, we very much look forward to moving that project through the various studies that we're well familiar with to move towards over time, hopefully getting it into production.
And maybe just briefly, I'm sure the board is aware, but the uses of potash and potassium and why it's so important to the economy.
Yeah, so it's used in fertilisers for farmers, and it's about 10 million tonne per annum market across the US at the moment. We understand the market could be substantially larger if there was more potash available locally and more fertilisers available locally. And we believe this asset has the potential to be potentially the largest producer of potash in the US over time. Obviously lots of studies to do, but the size of the resource potential down there is very large.
Can you talk a little bit about your plan for these 2 wells that are the subject of the request?
Yeah, the first thing we want to do is get in and take some bulk samples, a couple of 200 barrel samples, to really just classify the brine and really understand all the various elements in it. We know, there's some information publicly available on some of the potassium and the lithium grades, but really keen to understand some of the contaminants that are in the brine as well, because they can have quite an impact on the processing. So yeah, the first thing we'd like to do is get in and take that bulk sample, do the analysis, and then shortly thereafter put it through a process development, flow sheet development strain of work.
And if that sampling is successful, what are your plans for further development in the future?
Yeah, the next step after analysing the brine and doing the process test work will be to put out a preliminary economic assessment and an initial resource for the area. We've already got a large exploration target on the potassium and the lithium in the area. So next step would be the resource after the process development, put out a scoping study, and then move into the pre-feasibility or feasibility studies.
And you've obtained rights to how many wells at this point for the program?
Yeah, I think in our public statements we've said 24, but subsequently when we've had a good look at it, it's actually 23 wells, so a substantial number of wells, yep.
Okay. Let's talk about Utah Brine Corporation. Where was this entity formed?
Yeah, it's a Delaware company, and Neo Metals has its 51% interest, and we have a partner, Omaha Value Inc. Mike Luther out of Omaha is the 49% owner.
And has that company been registered to do business in the state of Utah?
Yes, we finally got our certificate of good standing, and all the paperwork's been submitted. So I don't know if it's up on the website yet, but all the paperwork has been put in.
Okay. Have you submitted forms to apply for operatorship of these 2 wells with the Division of Oil, Gas and Mining?
Yes, we have. Respect put them in for us. Yep.
I'm going to pull up exhibit number 1. Are these a copy of the forms that were submitted and the cover letter to the Board of Oil, Gas and Mining respecting your application for operatorship?
Yeah, that's correct.
Okay. What's lacking from these forms?
It's purely just the signature of Mandrake. All the other information, to the best of my knowledge, is correct. So.
And can you describe the status of obtaining bonds?
Yeah, we've been talking with Kerry down at the Moab field office from BLM about what bonds might be required. So we're just working through that process at the moment. I was interested to note the change in bonding that was just being talked about in the previous session. So we're just going through working out what's best to do that, whether it's once the amount's been calculated, whether to put it in as a cash or a letter of credit. That work is underway. Yep.
Utah Brine Corporation's got the financial ability to comply with those bonds amount and post those bonds?
Yes, absolutely.
Okay. So you mentioned the last step in the process toward sampling and getting underway is the assignment of operatorship.
That's correct.
Okay. Mr. Townsend, who do you understand to be the owner of the federal oil and gas leases at issue here?
American Helium.
Okay.
But we have an option to have an ownership, take over ownership of those assets. Yep.
Okay. And who did you speak with at American Helium Utah LLC to obtain these rights?
Humberto Servent, who's the CEO, president.
Okay. And are you aware of how American Helium Utah, well, I'm gonna skip that question for a minute. Mr. Servant submitted an affidavit. He described in Exhibit 2 this is a little awkward, I apologize. He describes in Exhibit 2 the fact that Utah Brine Corporation has ownership rights in this well, operator rights, and designates Utah Brine Corporation as their preferred operator. Is that correct?
That is correct.
Okay. At this time, I'd like to submit Exhibit number 1 and number 2 into the record.
Got it. Thank you.
I should be doing this one at a time here. Can you tell me
Okay,
the
hold
steps
on a
that you
second,
took?
Mr. Rommel. Any objections, Mr.?
Nope, no objections.
Okay, thank you. Yeah.
Mr. Townsend, let's talk about the steps you took to determine ownership of the wells. The first well is the Big Indian number 1. Well, let's say the first well is the Lisbon B912. The second well is the Big Indian number 1. Where did you go to determine the ownership of these wells?
Yeah, so a combination of doing our own work and using an attorney during the due diligence process. We went to the San Juan County Records Office online and searched through there to see if there was any records of any agreements or for Mandrake. We were unable to find any of those. We also looked at the official, I think they're the BLM records for each of the wells. Hope I've got that right, if it's BLM or Dogum, but there was no record of any interest to Mandrake on those 2 wells.
That's with respect to Mandrake, but what about with respect to American Helium?
Oh, absolutely. American Helium have the ownership.
And how do you understand that American Helium obtained ownership of these federal oil and gas leases?
They purchased it out of that Chapter 11.7 process.
And to be clear, the prior owner was Paradox Resources, who declared a Chapter 11 bankruptcy.
That's correct.
We'll talk about that more in a minute. So in your research at the Bureau of Land Management, did you review the serial register page for case number UTU 6922, which covers Township 30 South, 24 East, the south half, and the Lisbon B912 well?
Yes.
Okay, and I'm going to show you Exhibit 3. Is this a copy of the serial register page that you reviewed?
Yes.
And this has been certified. Is this, who is described here as the owner of the oil and gas lease at issue for the Lisbon B912?
American Helium.
Okay. And likewise, you looked at the serial register page for the Big Indian number 1 that covers Township 29 South, 24 East, Section 33.
Yep. That was American Helium as well.
That serial register page is shown on Exhibit 4. The legacy number is 67131B. Is this a copy of the serial register page that you reviewed at the Bureau of Land Management?
Correct.
Okay, and who's described as the owner thereon?
American Helium.
Okay, I'd move to submit these serial register pages into the record.
You're talking
Exhibits
about
3
Exhibit
and 4?
3 and 4?
Yes, sir.
Okay. Mr. Haynes, any objections?
No objections.
Okay. Admitted.
Okay. We're scrolling here. In your investigation of the BLM records, did you find a transfer from Paradox Resources into American Helium
Yes.
for both of the leases at issue?
Yes.
Okay. That was an assignment of right, title, and interest?
Correct.
Is this Exhibit number 5 a copy of the assignment you reviewed?
Let me just. Yes.
Okay. And this assignment notes that 100% of the rights without reservation were assigned to American Helium Utah. Is that correct?
Correct.
Okay, so I would move to submit exhibit number 5.
Mr. Haynes, any objection?
No objections.
Now that exhibit 5 is a long exhibit, as I see,
Yes, sir.
like 7 or 8 pages. Okay.
Contains
It's
a
admitted.
large number of legal descriptions. Okay, in your research about the nature of the ownership of Paradox, you mentioned earlier that Paradox declared bankruptcy. How was that bankruptcy filed? Are you aware?
It was in the Southern District of Texas in May 2023.
Under what chapter of the bankruptcy code?
It started off as an 11.
Are you aware of the date of filing of the petition for bankruptcy?
Yes, the 22nd of May 2023.
Okay. And you have reviewed the petition for bankruptcy?
Yes, I have.
Okay. Have you searched the petition for bankruptcy for mentions of Mandrake to see if they have an executory contract or some kind of right that exists in the context of Paradox's ownership?
Yes, I've searched that a number of times. There's no mention.
There's no mention of Mandrake in the petition.
No.
Did Mandrake enter an appearance in that case?
No.
Is Mandrake on the proof of claim as a potential creditor?
No.
Okay. Up on the screen right now, we have exhibit number 6, which is a petition for non-individuals filing for bankruptcy. Is this a copy of the petition that you reviewed?
Yes.
Okay. Move to submit exhibit 6. This is a fairly long exhibit.
16 pages, as I see.
No
Mr.
objection.
Haynes, any objection? Okay. Exhibit number 6 is offered and admitted.
Okay. So Mandrake has current operatorship. How did you learn about the nature of their agreement with Paradox?
There's a number of sources. There's an old investor presentation which you have here. I think it was slide 9 on memory. There's reference to it. There was also a ASX release dated the 21st of May.
And ASX means?
Australian Securities Exchange. Both Mandrake and Neo Metals are listed on the Australian Securities Exchange. So we've got some pretty strong obligations in terms of disclosure.
And what do you understand from the investor presentations and the disclosures? What do you understand about the rights of Mandrake to these wells?
Well, they may well have had some rights prior owners with Paradox upstream, but those rights are no longer valid. But having not seen the actual document of their well access agreement, I can't tell you the detail of it, but all I can speak to is the public domain information, which makes reference to the well access agreement being with Paradox upstream.
And Paradox's statement here says that they entered into an agreement, Mandrake's announcement here to their investors says that they entered into a well access agreement in May of 2023. Is that correct, to your understanding?
Yes.
What else happened in May of 2023?
The day after they announced their access agreement, the Paradox went into the Chapter 11 process.
Okay, and not to beat a dead horse, but you've searched the records of the San Juan County Recorder's Office, you've searched the records of the Bureau of Land Management, and you've searched the bankruptcy petition, and have you found any mention at all of Mandrake, or have they filed a notice of interest in any of those?
No.
Okay. I'd move to have this final Exhibit 7 submitted.
Mr. Haynes?
No objections.
Okay, it's offered and admitted as evidence.
I'd like to briefly discuss the steps that you've taken so far with regard to planning this project. Have you met with the Division of Oil, Gas and Mining?
Yes, we had our first meetings in November last year, which was very, very helpful. We found that the department extremely helpful and been very impressed. We've had a number of discussions with a number of different agencies in Utah so far.
Do you recall who was at that meeting?
Dustin was at the meeting. Also Gary White, the Assistant Attorney General, was at the meeting.
Okay. As well as yourself, and was there another representative from Utah Brine Corporation?
Yeah, we had Chris Reed there as well, our CEO, Managing Director.
Okay, and what other agencies have you met with in preparing for this sampling?
Yeah, so we've had discussions with various people in the San Juan County. Alan Humphreys, Curtis Page, Porter Hens is an environmental scientist, water quality Utah. We've had a number of discussions with the Division of Drinking Water and the Department of Natural Resources, working with Cash Stallings at the moment to basically get the temporary water appropriation permitting finalised. We're getting pretty close to having all the information he requires. So.
And you mentioned that you had a recent meeting with the Bureau of Land Management, their field office in Moab.
Yeah, last Tuesday, I think it was, caught up there with Carrie Williams, the geologist, and I've been liaising with Carrie in the last week or so, just trying to finalise these bond calculations.
Okay. So what obstacles are in your way right now for the development of this project?
Just being able to get in there and take that sample to do the proper characterisation and the process test work.
Okay. So Utah Brine Corporation has approached Mandrake for this transfer of operatorship?
Yeah, the forms were sent through officially to their office through our attorney. There was no response to that.
Okay. And have you received any kind of informal response from Mandrake as a company that specifically discusses the transfer of operatorship?
No, there was I picked up a phone call once from James Allchurch, the MD, I think, of Mandrake, and I just referred him on to Chris Reed to talk about it. That was the only interaction that I've had with Mandrake. So.
Okay, and to clarify, Chris Reed is who?
He's the managing director of Neo Metals, but he's also a director on Utah Brine Corporation.
Okay, those are my questions for this witness at this time.
Okay, thank you. Mr. Haynes, any questions of this witness?
Sure. Thanks, Mr. Townsend. So we've been talking about, you indicated that American Helium is the owner of the wells. Is that correct?
Yes.
In all the exhibits that you presented, could you point to where it shows that American Helium was assigned interest in these wells?
Yeah, I think it was back in the exhibits that we put in.
It would have been exhibit number 5, the assignment of record title.
Oh,
transfer.
Could you bring that up? I would like to see where it actually mentions the wells.
Uh-oh. Should not have closed my laptop. It says screen mirroring. I do have a physical copy of it here.
Yeah, this is exhibit 5. So this is transfer to American Helium. Okay.
Have you looked there?
I don't think I've got it.
This is my deal
That's
now.
not set
So
away.
from Paradox to, let's say, transfer or Paradox to American Helium.
Okay. Would you like to take a look at this? We don't have the digital, but I could pass this over.
Yeah, I'd like Mr. Townsend just to show where it mentions the Big Indian Unit 1 and the Lisbon B912 as being assigned to American Helium.
Okay, so this is the transfer form.
Township and range.
Here's the exhibit.
Township and range.
It doesn't specify the wells.
No, I don't think so. I don't see it.
So this is for the Lisbon, because it covers that area. It's in Okay, thanks for the help there from the technical team. This is the form that's used. It's a 3000-3 assignment of record title interest and lease for oil and gas geothermal resources.
Can you guys tell us what exhibit you're on right now?
We're on Exhibit 5, Mr. Chairman. And the label is partially blocking it, but the assignee is designated here as American Helium.
Okay, this is page 3 of Exhibit 5, okay.
Yes.
Okay.
On page 4, we have the assignor, Paradox Upstream, LLC. And then here on Exhibit A, 100% is owned, 100% is conveyed of the lease at issue covering the Lisbon Well, 29 South, 24 East, Section 30.
Oh, where does it say Lisbon Well?
Well, this is an assignment of the oil and gas lease.
Yeah, but you're talking about ownership of the wells.
Well, we're talking about ownership of the oil and gas lease. We're talking about operatorship of the wells. We're not talking about ownership.
Okay, but you're claiming that American Helium owns the wells. So where were they assigned the wells?
The question of the wellbore ownership is that there is I do have an exhibit, there is an assignment of bill of sale out of, that's recorded in the county from Paradox into the entities of American Helium that would include all of the assets. But my understanding is that when you sign an oil and gas lease, that it carries with it the appurtenances that are on site.
So an oil and gas lease carries with it the rights to produce oil and gas from those properties. Unless the wellbore itself is included in that assignment, I'm not aware if it gives you rights to that well. So if you have an assignment from Paradox to American Helium that includes the wells, yeah, we'd love to see that.
Okay, we can provide that. Maybe it's going to take a second to dig that up.
Okay. Yeah.
I don't think that's been requested before, but we'd be happy to provide that.
Well, I mean, at the end of the day, the crux of this is ownership of wells, and you've said you have the rights to be in the wells, that American Helium owns the wells. We've just never been shown anything that says they own the wells.
Well, we're not asking the board to determine ownership of wells. We're asking the board to identify the owner of the oil and gas rights, which is their statutory duty. And from there, we're asking the board to recognize an operator that the owner has designated. So we're not asking for the physical transfer of assets. The board doesn't have the authority of the jurisdiction to transfer the physical assets of the property to anybody. That would,
sure.
If Mandrake had an issue with who owns the physical infrastructure of the well, that would be a civil matter handled down in 7th District. And so I just don't see how that's relevant. We've identified we've identified the owner. They've designated an operator.
The owner of what?
The owner of the right to produce oil and gas.
Okay.
From these lands
and
through this oil and gas.
And if that's correct, that's not in dispute.
Perfect.
What's being asked here is to be designated the operator of 2 wells.
Correct.
That we have seen no indication who owns those wells.
But there's no provision that requires. We've identified the owner of the properties and their designated operator, and so we can also provide the bankruptcy assignment bill of sale to the actual infrastructure, but it's going to take me a minute to dig that up.
Yeah, because
okay, hold on a second. When you say it's going to take a minute, or are you talking it's going to take getting down to San Juan County and getting those documents?
No, I've got it on my laptop.
Oh, okay. So it's something that potentially we could resolve this somewhere along the line.
Yeah, members.
Because I don't want to send
members of the board. This is done through a change of operator form, typically, which has the current operator who has the rights in that well, who then says, "Hey, here's the other party; they can now operate." If we can't get the old operator to say that they're going to sign off on this, we at least need to see why you have a legal right to be in those wells. Not a legal right to who has a lease, because sure, you can take your lease, you go drill a new well. We're talking about an asset that a party owns that we have to see before the division can approve a change of operator. We have to see you have a right to be in that well. And if there's a document that shows that a party was assigned that interest in a well, and now that interest is somehow assigned to Utah Brine Corporation, which I've never seen that either. This is an administrative procedure. We just have never seen the documentation.
Okay. Can we take a recess and you guys get together and sort this out? 10 minutes? Oh, go ahead, Steve.
Just to make it clear for me, who does the division show as the current as the operator of record that you have, and who is bonded on these wells?
So the current operator in the division's records is Mandrake Lithium USA. The bond is actually held with the BLM because these are federal wells.
So Mandrake is the bonded party.
I don't know. I don't know who the BLM has their bond with.
Okay.
Could I ask?
Go ahead. Yeah, go ahead.
If there are 23 or 24 wells involved in this transfer, why are you only requesting 2 wells?
There's only 2 wells out of the 23 that have a different operator.
Thank you.
Okay.
And the operator of the other wells are, who's your operator?
American Helium.
Okay. Mr. Haynes and Mr. Rammel, how long do you think it would take, if we take a recess, how long do you think it would take you to resolve this issue?
Yeah, if they have the document, yeah, it will not take long at all to see if the wells are listed on that document.
Okay. Is that 10 minutes, 30 minutes, an hour? What is that?
Let's say 10 minutes.
Okay, we're going to go on recess until 11 o'clock. By this clock, we're off the record. Okay, I understand Mr. Rommel and Mr. Haynes have had discussions here on how to proceed, so
Yeah.
who wants to describe what's going to happen here?
I'm happy to go first.
Go ahead.
Yeah, thank you. So after our discussions, we believe the division can take care of this administratively. So we're going to attempt to resolve those gaps that we thought were there before. With that, we'd like to ask for a continuance, though, till the July board hearing, just in case something comes up where it doesn't get taken care of. And that way, we preserve what they have already done. So that's the proposal the division has before the board. And I believe they also would like to add something to it.
Mr. Rommel,
do
you concur?
I do, and I would just like to clarify that we did provide this assignment bill of sale for the actual physical property of the well in our first exhibit and witness list, and so the division has a copy of that, and they've reviewed it again now, and we've gone over that those assets are included. And so we'll continue to work with the division. We'd ask for the continuance if Mr. Townsend could appear electronically. We'd move for that so that he doesn't have to take
Approved.
900 flights back. to Salt
Approved.
Lake.
If that's necessary, certainly approved. Mhm.
Okay, thank you.
And if you have other witnesses at the time, we'd consider that also.
Okay.
Okay. So the idea then is we're going to continue to July. July is probably a good time to continue to because we only have 3 items on the agenda for July. This would be the 4th. We have 4. Okay, so this would be the 5th item on the agenda for July. So it'd be about this same time of day, and wherever you happen to be, Mr. Townsend, it'll be 11-ish here in Utah. So how do we, do you one of you make a request, or do we just make a motion that we continue to July ourselves?
Yeah, we're making that motion to continue to the July hearing.
Okay, so you're going to amend the request for agency action to make an appearance or continue until July.
No, we're just making the motion to do it.
Okay.
And you can do that.
Okay.
Approve the motion.
Anybody got a problem with that? Okay, do it that way then.
So say motion approved.
Motion approved.
Thank you.
Thank you. Thank you.
Chairman and member of the board, thank you.
And thank you for coming all the way up from Perth. Good luck with this. I think we understand the magnitude of this request and what you're trying to do, and we really want you to be successful in that. So,
Thank you very much, Mr. Chairman and fellow board members.
thank you. Okay, so we're going to move on now to agenda item number 3. And let me get to the right place in my papers. So this would be concerning Crescent. And I'll go ahead and read this into the record while you guys get set up. Okay, agenda item number 3 is docket number 2026-027, cause number 130-50, in the matter of the request for agency action of Crescent Uinta LLC for an order, 1, establishing laydown 1,920 acre drilling units, and 2, establishing laydown 2,560 acre drilling units for the long lateral horizontal well production of oil, gas, and associated hydrocarbons from the lower Green River and Green River Wasatch formations of Section 36, Township 1 South, Range 4 West, USM. B, Section 13 to 22 and 25 to 35, Township 1 South, Range 3 West, USM. And C, Section 31 to 34, Township 1 South, Range 2 West, USM, sections, and D, Sections 1 and 2, and 11 to 14, Township 2 South, Range 5 West, USM, and E, Sections 1 to 18, Township 2S, Range 4 West, USM, all in Duchesne County, Utah. With that, we'll take appearances for council.
Brent Chicken, Steptoe and Johnson, PLLC, Denver, Colorado, on behalf of applicant Crescent and Crescent Uinta, LLC.
Okay.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Okay, thank you. Go ahead, Mr. Chicken.
Today's request is a fairly straightforward request for 28 overlapping laydown 1,920 acre or 3 mile DSUs and 20 overlapping laydown 2,560 acre or 4 mile DSUs, not to be confused with a 2560 section line. We are not requesting those today. These are just straight up laydowns of 3 and 4 governmental sections. We are requesting that those, each one of those DSUs be approved for up to 37 long lateral horizontal wells, which are lateral well bores of 2 miles or more. 100-foot east-west or heel-toe DSU boundary setbacks, 330-foot or north-south lateral DSU boundary setbacks, and no producing interwell setbacks between these new wells and existing long, short, horizontal wells or directional and vertical wells. I've got a couple of housekeeping items to go through, and all of this has been shared with counsel for the division and the board since the filing of the RAA. We've had some changes, we've had some negotiations that are leading to this, and so I'm going to list the vast majority of these things are either typographical or ministerial errors that don't really affect the request or the outcome or a requested outcome granting the RAA, but we wanted to make sure that the division and the board were aware of them. The first one is very simple. There's a couple of places in the RAA in paragraph 20 where there is we're asking for 1,290 acre DSUs instead of 1,920 acre DSUs, so I apologize for those typographical errors. So that is one. The second one is in your RAA, you try to do the best you can to accurately describe for the board and for the division the existing board orders that may be impacting the subject lands that you are requesting the board take action on. And in this case, paragraph 2 of the RAA lists a bunch of lands, a bunch of the lands that are part of our subject lands, and says these are unspaced, that they're not subject to a board order. And I'm sure as the board is aware, sometimes the board record search function on the website it doesn't always get you exactly where you want to be. And so rather than those being unspaced lands, those lands are actually subject to, the paragraph 2 lands in the RAA are actually subject to Board Order 139-159. That was docket 2018-022. This is from back in February of 2019. It created laydown 1,280 acre spacing units with 12 wells in each, 330-foot heel toe, setbacks 560 lateral setbacks, and 330 interwell setbacks. And so because the request today is for overlapping spacing and it does not impact the existing spacing that is out there, this is the difference by saying these are unspaced or saying they're subject to Order 139-159 doesn't really change the nature of the request or the board's analysis of the same. But for purposes of being accurate before the board and making sure that what the board is looking at is accurate, those paragraph 2 lands are subject to Order 139-159. And importantly, we're not asking to amend that order or anything like that. We're just there's 1290s on those parts of the subject lands, or there's 1280s on those portions of the subject lands right now, and we're overlapping them with 3 and 4 mile DSUs.
Are you on board with that, Mr. Haynes? I'll call that.
Yeah, as Mr. Chicken indicated, we've had communications on this, and so we're aware of the changes and we're okay with them.
Okay, you good with that, Sandy? Okay, thank you.
We also, in an effort to be as inclusive as possible, we like to list our existing wells as part of our RAA. Due to an internal misunderstanding of what those existing wells should be, we have listed 11 wells on that list that probably shouldn't be there. And these are the Braveheart, Die Hard, and Jurassic wells. These 11 wells have surface locations on our subject land, but they produce from DSUs outside of our subject lands. So they're technically not an existing well as is understood by the division and the board on the subject lands. So those were listed in there, and they probably shouldn't have been. But again, a very ministerial thing to remove those 11 wells. And Mr. Chairman, I'm gonna ask the board to approve an amendment once I'm done with these couple of housekeeping things, so that it's been formalized.
So this is your first exhibit, but then Exhibit A of your the Exhibit A of your RAA.
Correct. Exhibit A to the RAA is wrong. The exhibit with the existing wells that I'm going to show you today, that's accurate, and it does not include those 11 Braveheart, Die Hard, and Jurassic wells, which just have surface. They're horizontal wells that have surface locations in our subject lands, but we are drilling down and in, and then they're not perforated until they're in a DSU outside of our subject land, so they're not producing from our subject land.
Okay, so we're going to take those 11 wells out.
Yep.
You'll give us an amended RAA.
I'm going to motion to amend for these 4 items, just so that everything's clear. And then
You good with that, Mr. Haynes?
Yes, we're okay with that too. Thanks.
Good, thank you.
And then lastly, the subject lands as put forth in the RAA include all of sections 31 to 34, Township 1 South, Range 2 West, USM. After the filing of the RAA, Crescent was contacted by another operator who had some different ideas for the development of these lands. Rather than creating a contested hearing today before the board, Crescent is instead working with that operator to come to an agreement for how to develop those lands. And as part of that negotiation and understanding, we will be removing those lands from the subject lands we're not asking for anything to be done with those today. They will just cease to exist as part of the request.
So that's subsection C of your RAA?
Yes, it's sections 31 to 34, Township 1 South, Range 2 West, USM. Those lands are no longer part of the subject lands in order to avoid, we're negotiating instead of fighting in front of you guys, which we assume you. Yes, exactly. And so I will make my motion, and the proposed order will also reflect this discussion here. But I would motion to amend the RAA to correct the 1290/1920 typographical errors, the paragraph 2 of the RAA, lands being subject to Board Order 139-159, the removal of the 11 incorrectly listed wells from Exhibit A to the RAA, and the removal from paragraph 19 of the RAA of the sections 31 to 34, Township 1 South, Range 2 West, USM lands.
Okay. Mr. Haynes, do you have any issues or objections to what Mr. Chicken's proposing here?
No, again, we were aware of these changes and we know about them. We have no objections.
Okay, so we'll go ahead and let you make that amendment. So your motion is granted to make those.
Yeah, and I'll
three
make
or
sure
four
there's
amendments. So.
I'll make sure there's a section in the proposed order that both division and board council can review to make sure that we're accurately capturing this. So somebody 2 years from now looking at the RAA and looking at the order would understand why those differences exist.
Yes.
If they were to do that. So beyond that, on May 27th, a response to the RAA was filed by a gentleman named Dusty Hansen. Subsequent to the filing of that request, Crescent Uinta representatives engaged with Mr. Hansen, discussed the nature of his response and the issues that he raised, answered his questions and worked with him. And on June 9th, Mr. Hansen filed a written withdrawal of his response to the RAA. So again, just making sure the board's aware of that was filed and withdrawn. I think there was just some misunderstandings, and Crescent and Mr. Hansen were able to, see eye to eye once there was a better understanding of the nature of the request. On June 10th, a response was timely filed by the division, with the main issue raised in that response being that the previously described Order 139-159 created 1280s with 330-foot heel-toe setbacks. We are asking for overlapping 1920s and 2560s with 100-foot heel-toe setbacks. And so there was a question of, by the division of, did that protect correlative rights? How is this going to impact various, various other similar issues to that, ultimate recovery, things like that. And we'll get into that a little bit more. In response to that, representatives from Crescent Uinta met with representatives of the division and had technical discussions regarding this issue. That resulted in a recent motion the board granted to supplement and add 2 exhibits to the exhibits that Crescent filed on May 26th that are designed to specifically address that issue raised in the division's response. And we have we have Mason here today. He's going to be our engineer. He can testify. He's going to specifically go through those exhibits. And I'm sure if Megan or other division folks have questions, we can answer those questions today. My understanding is that subject to the satisfactory discourse regarding those questions, that the division does not object to the granting of our request. They just want to make sure that we've done our homework properly. And so we believe we have, and we're going to be able to present technical engineering and geology evidence on that today. And then along those same lines, I would ask the board, I'm not going to list, I'm not going to go through all these. I have a really long list that I'm not going to read to all of you here, but this is in further support of the 100-foot east-west or heel-toe setbacks that we're requesting today. I did a little bit of research, and I found no less than 30 board orders that have similar subject formations, our kind of 4,000-foot pay stack we have here in Utah in the Uinta Basin. I found about 30 different board orders that approved 100-foot heel-toe setbacks for long lateral horizontal well development. I'm going to list a few of them here just for purposes of the record, but I would ask the board to take administrative notice of its prior holdings in. I'm just going to go with the most recent ones. So 13049 was from March 9th. Cause number 13049. Cause number 13048 was also from March 9th. And then I'm going to mention 13046 and 13047 are from February. So this is February and March of 26. But I found orders, and this is just in the 130 cause numbers. So there's similar orders in the 430 cause numbers and the 600 cause numbers. And I found these going back all the way to about early 2024. So it's been something that the board has granted in horizontal heel-toe setbacks for at least 2.5 years now.
And right now we're on 130-50, so
correct.
Just a couple left.
So and that's why I'm asking you to take administrative notice of those more recent 130 cause number orders. I'll also note that there was a public comment letter filed on June 9th by Ammon McDonald. Crescent Uinta representatives have engaged with Mr. McDonald and discussed the nature and issues, the nature of and the issues raised in his public comment letter. I believe they've answered some questions, but I think Mr. McDonald is here today to offer public comment at some point on this, and we can address, the board and the division along with Crescent representatives can address anything in that public comment. And then lastly, before we get going on our with our presentation of evidence, I have three witnesses with me here today. Sitting to my left is Mr. Dan Brooks. He is a senior landman for Crescent Uinta. And seated behind me is Matthew Baker, who's a staff geoscientist at Crescent Uinta, and Mason Whittington, who is a staff reservoir engineer for Crescent Uinta. Mr. Brooks is going to present factual land testimony and evidence. Mr. Baker, I'm going to ask be qualified as an expert in petroleum geology, and he has not appeared before the board before. And Mr. Whittington, I'm going to ask the board to qualify him to present expert engineering or expert testimony in petroleum engineering, and Mr. Whittington has appeared before this board and been qualified as an expert before this board. And so I don't know if the board wants to swear folks in now or how you want to go next, but.
Yeah, please raise your right hands. Do you swear that the evidence you're about to give is truth, whole truth, and nothing but the truth, so help you God? Yes. Thank you. I got them all.
Just making sure you can make that eye contact. My first witness is.
And I think when we get to Mr. Baker, we'll just ask for a quick qualification there. So.
Okay, not a problem. My first witness is Mr. Brooks, sitting to my left. Mr. Brooks, if you could please state your full name, your association with the applicant, and your current business address.
Yes, my name is Dan Brooks. I am currently the land manager at Crescent Energy Company, and my address is Crescent Uinta LLC, 600 Travis Street, Suite 7200, and that's Houston, Texas 77002.
Thank you. These are our table of contents. We'll move right into Mr. Brooks' first exhibit, which is Exhibit L1. And if you could please describe what is depicted on this regional aerial map and what we're looking at so we can zoom in from this point.
Absolutely. So L1 is our regional aerial depicting our RAA 130-50 lands. You'll see the consistent exhibit nature throughout, and the red outline of our lands here today are our subject lands. So the lands are about 2.5 hours southeast of here, or east-southeast of here. Located just due north of Duchesne and due west of Roosevelt. And the lands comprise of about 30,000 acres.
And just to be clear, this map and all subsequent maps that we've prepared already show that sections 31 to 34 and 1 south, 2 west gone and not depicted here, correct?
That is correct.
Okay. Moving into Exhibit L2, if you could please describe what's depicted on here and also describe the notice of this RAA and of today's hearing that's been provided by Crescent.
Yes. So L2 is, again, as Brent mentioned, our notice outline with the half-mile notice buffer. And as you've seen Crescent testify before, not only do we go out a half a mile or so, but we actually take that out a full section. So the green line exhibits the full extent of the lands that were noticed. The quick summary there is there's 46 sections, or like I said, about 30,000 acres in red, and then an additional 46 acres or an additional 30,000 acres that were noticed that encompass the entirety of that green line. We physically affected about 2,400 mailings in this process, and yeah, that's what I have there.
Okay. And so that means you've sent a true and complete copy of the as-filed RAA to all parties whose legally affected rights inside of this green outline that may be affected, correct?
That is correct.
Okay. We'll move on to Exhibit L3. This just describes the general mineral ownership in these lands. But if you can kind of flesh that out a little bit, please.
Absolutely. So yes, in terms of the mineral ownership, you can see The lands are predominantly fee acreage with some tribal acreage in there as well. A couple things I would make note of here on this slide is across the entirety of our lands requested here today, Crescent is the only operator across all of the lands. And currently we operate or control about 90% of all the working interest across the lands. So currently the only operator and the far majority working interest owner across the lands.
Okay, thank you. This is kind of given an idea, and this captures the concept that I talked about before about the prior orders that are existing. If you could please describe what this is depicting in terms of what is out there now in terms of board orders.
Yes. So I'm going to tell a little bit of a story in this slide and to the next slide on L5. But as you work down on the exhibit, the peach lands, that is current order 139-159. The green order below that is 130-36. And really, I'm going to jump to the right side in the wording, and we're going to work up because that's backwards. So really what you're seeing here is a vintage of when and how these lands were spaced. The existing order 139-159 was done back in 2018 or 19 timeframe. And really the onset there as Crescent's predecessor went up there was a 12 well density, 330 inner well setbacks, 560 from your section or unit lines, and then 330 east-west. Then as we more recently, towards the end of 24, Crescent appeared before the board as Javelin at that time, and amended some of those lands. And some of those lands I'm talking about are kind of that very southern border there, 13 through 18. Yes, that row there. Mm-hmm. And so we amended a few of those under 130-36 to more closely mirror what we're doing today. At a well density of 37 wells, we dropped the inner well setback to 100 foot, and 330 heel and toe, or excuse me, 330 from the DSU setbacks. So I think that's important to just understand that context as now what we've most recently requested just a couple months ago in 612 is going to go to very similar, which if there's no more questions here, I'll continue the story on the next slide.
And I can go to Exhibit L5. There you go.
And so just jump into kind of the crux of the issue is now current day what our belief is with these 1,920 acre, 3 mile laydown DSUs. We're asking for 37 wells density wise, 0 foot inner well setbacks, 100 foot heel and toe setbacks, and then the north and south boundaries being 330. And I think as Mason will show you guys later in the slides, and kind of walk through the math behind that, that is our current understanding of how to best develop where we have vertical wells, where we have 1280s, where we're going to have now 3 milers. So that's our current approach. Now, specifically on this slide on L5, we're requesting 26 total 1920 3 mile units. And as you can see, though, those overlap throughout. And I think that's very important for our current scheme as well, as we get up to these lands and really understand operationally where the best surface location for minimizing surface impacts. So that's where you see all the overlapping. I don't think the intent would ever be to go fully develop all these kind of overlapping in different natures. But that's the request here.
Right, and the nature of these overlapping spacing units is, in your understanding, is such that they are, even though the spacing units overlap, the wells requested are cumulative footage totals that you cannot exceed. So it's not 12 wells in a 1280 and then 37 in a 1920 and then 37 in a 2560, correct?
That's correct.
Like all this would allow you to do is 37, including that total footage.
That is correct.
Okay. We'll move to Exhibit L6, which is your 2560 or your 4 milers.
Yes, so very similar here, showing the overlap scheme on requesting of 19 total 2560 or 4 mile east-west DSUs, and that will be the same request at a well density up to 37, 0 foot inner well, 100 foot heel and toe setbacks, and then 330 foot lateral or section line setback.
Okay, and so that means your well density and your 3 setback areas for your requested 1923 milers and 2564 milers are the same, correct?
That is correct.
Okay.
By the way, Mr. Chicken, before you go on.
Yes, sir.
I like how you've got Exhibit L5 and L6 laid out with the graphics there and then the summary of the spacing on the right-hand side. So
We
that's
think
all.
it's important to connect what you're seeing here, which is the textual description of each one of those DSUs, but then also actually see them on a map, the box, the boxes of where they're going to be. It helps really better understand.
And to have the setbacks set down there also, because so many of these numbers are bouncing around fast. So thank you. Thank you for doing that.
This is Exhibit L7, and this is not a specific development, but I think this is one that, if you can please describe what you're depicting here as a possible development scenario.
Yes, L7, and we've presented this slide before, is just as we think about the iteration through the basin where it was 4 wells or 8 wells vertical, and then it was 12 wells in a 1280, and now we're talking about 37 wells. But just to show, picking only 4 productive intervals on how a full development for a 3 mile unit might look. My geologist behind me is probably laughing at me on this exhibit, but this is just by way of example, just showing what full development may look like. And then importantly, I always like to emphasize this, that we do believe this maximizes resource recovery, minimize waste, and protects correlative rights.
Okay. Can you tell what the red and green means?
We were just trying to do whether that was going to be like for that, the red could be a 1280 because it's overlapped, and then the green could be the 3 4 milers. But that gets at Mr. Chicken's point of, it's not 37 per DSU, sure. It's just per section there.
Okay, thank you.
Okay. And the grand finale, which has, this is why we try and separate them out. If you could describe what's depicted, recognizing it gets kind of busy.
Yes, it does get busy, but I think the point here being is one, the 26 overlapping 1920s and then 19 overlapping 2560s. And really, it does get busy, and we talked a lot about this on how to show this, but I do think this provides for the most agility operationally. As we learn things, as we figure out different ways to do things, maximizing surface impact or minimizing surface impacts. This does provide for that optionality. And then two, just wanted to simply lay out then again on the sections involved in the ultimate request on densities and setbacks.
And just to be clear, this also, part of the reason it's very busy is because this also shows those existing 1280s under Order 139-159, correct?
That's correct.
Okay. I have no further, actually I do. Were exhibits L1 through L8 prepared by you or under your supervision, direction, and control?
Yes, sir.
And based on your testimony and exhibits today, do you believe the relief sought in Crescent's request for agency action will protect correlative rights, prevent waste, maximize resource recovery, and minimize surface impacts?
Yes, sir, I do.
Okay. I have no further questions for Mr. Brooks.
Haynes?
Thank you. Mr. Brooks, can you just remind me, what were the sections that we withdrew? Was it 23 and 24? Or do I have that wrong?
It's
Brent's going to highlight it there.
Okay.
It's that 31
these right here.
Right there.
Okay.
Yep.
With that in mind, then, I do have a question about 23 and 24.
Okay.
I noticed that, they're carved out of a neat little box there. Could you just explain to me why that's not part of this request?
Yeah, it's a simple answer in ownership.
Okay.
And
Not ours.
to the extent we own that, this would be in there. I don't think that precludes any sort of further development and negotiation with other operators. But the short answer is we're trying to space what we own. And
Okay, great. And you don't have to tell me who it is, but whoever the operator is in that region, were they noticed about this request?
Yes, and they may or may not be here sitting behind me.
Great.
But they, yes, and they were very involved
Okay.
with dropping of those 4 sections and properly noticed, yes.
Great, that's what I need. I do have a question. Let's go back to that last one. I think it was L8. As was indicated earlier, there's the existing 1280 acre units in 1 South, 3 West that were not indicated in the RAA. With that in mind, now that we kind of know there's 1280s, now there's going to be 1920s and 2560s, is there any plans to continue to develop 1280s, or just give me an idea of, now that you have all this flexibility, what you envision happening?
100%. And I may punt a little bit of that question to our engineer, but I would tell you from a development standpoint and learning standpoint, we are still very much in the first couple innings of understanding 3 miles versus 4 milers. So if there's a world where that all checks out and cost-wise, recovery-wise, and all of that is greater in the 3 and 4 milers, maybe there's not as many 1280s drilled. But I also think there's a world where, given vertical wells are still very economic in this basin. It's just they're not quite as economic as we can achieve through 1280s or hopefully 1920s. That's the way I would answer that. It still provides for that flexibility.
Thank you. No further questions from the division. Thank you.
Okay. Board members? Go ahead,
So, Mr. Brooks, if you could remind me again of your intent as far as 0 interwell setbacks. You don't intend to intersect any vertical wells?
No, sir.
So it's your intent to avoid them, even though there's no interwell setbacks?
Yes, sir. And we were having that conversation this morning. Even though that setback is a 0 effectively, there's no way from a well control safety measure, impacting our asset that we ever intend to actually drill directly by that well. It's just the opportunity of kind of snaking these wells through the vertical wells that, you may get closer than 330 or 100. But no, to answer your question, no, we don't intend to intersect them.
Good. Okay. Board members, any other questions? Okay, thank you, Mr. Chicken.
You are excused, sir.
Thank you. Thank you.
I will call my next witness, Mr. Matthew Baker.
Okay. Now, as I understand, Mr. Baker hasn't testified before the board before.
He has not, and I'll ask him to state his name, title, and a brief history. So if you could please state your full name, title with Crescent, your business address, and then it is part of the exhibit pack, and I'll go to it right now, is your resume, please.
Hi, yes. Can you hear me?
Yes.
My name is Matthew Baker. I'm a staff geologist at Crescent Energy. I've been there for a little over a year. Our business address is 600 Travis Street, Suite 7200, Houston, Texas 77002. And in terms of my brief history, prior to working at Crescent, I was at Marathon Oil for a little over 13 years. I started there right out of grad school. I started in working geologic operations in the Eagle Ford Basin in Texas. I did that for about 2.5 years, doing well planning, geosteering, things like that. Then moved to the Gulf of Mexico, Gulf of America exploration team for about 3 months before Marathon decided to divest those assets. Then I moved to the Wyoming asset team, kind of working some of our very old vertical fields in Wyoming. That lasted about 8 months before they decided to divest those assets. And then I went back to do more operations geologist work. At that time, we were forming a centralized team where we were doing the operations work for all 4 of Marathon's assets. So the Eagle Ford, Bakken, Oklahoma, and then eventually the Permian Basin once we re-entered that in 2016, I believe. After about a year of that, or about 2.5 years of that, I moved to the Permian development team where I did kind of full field development planning for how we were going to tackle our development strategy in the Permian Basin. It's very similar to Utah, where you have a lot of stacked pay, several thousand feet, what formations you're going to target, how those formations or wells are going to interact with each other. I did that for about 6.5 years before ConocoPhillips, kind of the merger was announced. I think that deal was closed in December of 2024. I had a short transition role with ConocoPhillips until February of 2025, and then was severed because I did not want to move to Midland, Texas. Nor did my wife. And so I took a few months off and then started working for Crescent. I think it was around the last week of May in 2025, and I've been there ever since, working the Uinta Basin.
And you have a bachelor's in geology and a bachelor's in geophysics from the University of Montana, along with a master's in geology from the University of Kansas, correct?
Bachelor's from University of Minnesota.
Oh, yes, Minnesota, sorry. And then maybe you could give the board just a little bit of your what you've been doing and working on primarily in the Uinta Basin.
Yes. So my first 6 months, they brought me on to kind of do an evaluation of all their old vertical wells throughout the basin, looking at them, kind of what to do with them. If there was any remaining uphole potential that we wanted to test for various formations to see if they were producing in various areas, as well as things that had been, completed all the way up through the lower Green River, what to do with those, if there's any, kind of treatment options we could do. I think it gave me a pretty unique perspective of the basin, kind of looking around, because these assets have been owned by several operators over the years, kind of seeing their strategies, what particular formations they were targeting in the vertical wells, where their perforations were, which specific benches within the formations, to kind of get a good picture of kind of where the best areas were within each formation and, where the best production was. And then most recently, the last 6 months, has been kind of moving over to the horizontal development side, kind of figuring out future field development, appraisal, where we want to drill, and what formations we want to target.
Okay. I don't have any further questions. If the division or board would like the voir dire.
Division, any issues?
No, the division's reviewed Mr. Baker's resume, and we're okay with him being recognized as an expert for this matter.
Okay, board, any issues? Seeing none, proceed.
Okay. I motion that he be recognized as an expert in petroleum engineering.
So
Petroleum geology, sorry.
Yes.
All right, we'll get back to his. All right. Exhibit G1, if you can please describe what's depicted on Exhibit G1.
Oh yeah, so this is the outline for the area of interest for today. Shown on the map are the locations of existing oil wells as well as abandoned wells. You can see that there has been no horizontal development to date within our area of interest. I think by my count, there are 34 active oil wells and I believe 101 abandoned oil wells within our area of interest.
Okay, and this Exhibit G1 does omit those 11 I'll call them the movie wells that were on our existing well list to the RAA, correct?
Correct. Yes, they do.
Thank you. Exhibit G2, if you could describe the type log being shown here.
Yes, this is just a type log from the Allen 39B4, kind of showing the productive intervals within our acreage, which for us, we are targeting the lower Green River and Wasatch formations, so from the TGR3 top and below, but we also included the upper Green River as well as the Uinta formation on there.
Okay. And that Allen well is shown by the blue star in the inset map in the lower right-hand corner, correct?
Yes, it is.
Okay, thank you. Moving to Exhibit G3, if you can please describe what is shown, recognizing that it's tough with resolution when you're comparing 6 wells.
Yes. So this is a geologic cross-section from A to A prime, so moving from west to east or west to northeast across the area of interest. This is just kind of showing the primary formations for the Uteland Butte and above, which we kind of classify as above the Uteland Butte as the upper cube. Showing that all of the formations are present. One thing to note is that the Castle Peak does seem thin as we move to the west, but it is present in 1 south, 3 west, I believe. It's present all the way across, but gets thin as you move towards to South 5 West.
Okay, and this also shows all of the other subformations as well, correct? Garden Gulch, Douglas, the ones listed to the right of the main graph?
Correct.
Okay. We'll move to Exhibit G4, if you can describe what's shown on the structure map.
Yeah, this is just your standard structure map from the top of the Uteland Butte, showing that in this area, it's primarily dipping from south to north within our area of interest.
Okay, and then what does that inform in terms of the dip?
That we will be drilling parallel with strike, so most of our horizontal wells will be at approximately 90 degrees horizontally.
All right, and so that supports the request for laydown spacing to drill east-west, correct?
Yes, it does.
Thank you. Now we'll get to the more technical piece of that. Describe your SH Max Exhibit G5, please.
Oh yeah, these are just a couple examples of our SH Max orientation taken from borehole breakouts from some vertical wells that we had that information on. You'll note that the western side is essentially SH Max is running north-south with some subtle shifts of 5 to 7 degrees in either direction. Moving to the east, we do see a slight rotation, which would be more towards about, I think, 26 degrees north, 26 degrees west. So you can see that SH Max rotation as you move to the east.
And so the perpendicular intersection with those natural fractures is actually going to get better as you move from east to west, correct?
Correct.
Exhibit G6 is similar to Mr. Brooks' 3D box model, correct? If you could describe what's shown here as far as potential development.
Yeah, so this is just kind of a generalized kind of landing diagram look or gun barrel view for our acreage throughout the basin. You'll see, just in terms of generalized spacing, Uteland Butte was typically at 4 wells per section. Our understanding right now is in the other benches is about 3 wells per section. And you can see all of the target, the larger formations as well as the sub-formations within those that look good for horizontal development.
Okay. Were exhibits G1 through G6 prepared by you or under your supervision, direction, and control?
Yes, they were.
And based on your testimony and the exhibits presented today, is it your opinion that the relief requested in the request for agency action will protect correlative rights, prevent waste, maximize resource recovery, and minimize surface impacts?
Yes, I do.
I have no further questions for Mr. Baker.
Okay, Mr. Haynes, any questions?
Thank you. The division has no questions for Mr. Baker. Thank you.
Board, any questions? Seeing none, thank you.
Your excuse, sir.
Thank you very much.
I'll call Mr. Mason Whittington as our next and final witness. Mr. Whittington, if you can please state your full name, position with Crescent Uinta, and your business address for the record.
Yes, I'm Mason Whittington. I'm a staff reservoir engineer with Crescent Energy. Business address is 600 Travis Street, Suite 7200, Houston, Texas, 77002.
And you have been previously recognized as an expert in petroleum engineering by this board in prior matters, correct?
That is correct.
Based on his prior qualification, I would request that Mr. Whittington's testimony today is taken as expert testimony in petroleum engineering.
Okay, Mr. Haynes?
I have no objection.
Board, any questions? It's approved.
Thank you. We'll start with Exhibit E1. Can you please describe the kind of story we're telling here about the development of the Uinta Basin?
Absolutely. So this is just trying to highlight the recent activity in the Uinta Basin in recent years. If we can draw your attention to the chart in the top left, those are approved permits over 9,000 feet. So this is going to be horizontal approved permits. The green bars represent roughly 10,000 feet or your 2-mile laterals. The yellow bars are roughly 15,000 feet or roughly 3-mile laterals, and your Red bars will be representing roughly 4-mile laterals or 20,000 feet. As you can see, in about 2020, since 2020, there's been a rapid increase in basin activity. And part of that activity is some innovative ideas on extending out laterals to drill 3 and 4 mile laterals that you can showcase. That's what I want to draw your attention to the chart in the top right. It's still approved permits over 9,000 feet, just shown on a percentage basis. And you can see in 2023 and onwards, there's been a gain of momentum of 3 and 4 mile laterals. And as of 2025, a little over 30% of all the approved permits were 3 or 4 mile laterals. And so far in 2026, about 20% of all the approved permits are 3 or 4 mile laterals. And then on the bottom, that locator map that just showcases where those approved permits are located throughout the Uinta Basin, and they are still color-coded by the respective lateral lengths in our bounding crescent acreage position.
And just to be clear, this is the 4 miler down in here, right?
Correct.
That thin red line?
Yes, it's kind of hard to see, but yes.
Okay. We'll move on to Exhibit 2. If you can please describe what's depicted on this exhibit.
Absolutely. So this goes to support for our no interwell setbacks. This is updated production plots from previous exhibits we have shown, and it is just showcasing the impact on vertical wells from horizontal fracturing operations. The first black line on the left is when we did our first round of horizontal activity in this particular area. At that point in time, we had 330-foot setbacks. As you can see, these vertical wells depicted on the slide here had positive or neutral impacts due to those horizontal fracturing operations, which is a typical response that we have seen across our acreage position. About a year later, we came back into our second round of horizontal activity, which is depicted on the black line on the right. However, at this time, we had reduced setbacks of 100 feet. But once again, these vertical wells saw positive or neutral impacts from the horizontal fracturing operations. So we do believe this trend will continue to hold and be representative of the subject lands today and maximize resource recovery.
Okay, and so this is in further support of the request for 100-foot heel-toe setbacks.
This is for the no interwell setbacks.
I'm sorry.
But yes.
That's why you're the engineer. Exhibit E3, this is our heel-toe and lateral setbacks exhibit. If you can please describe what's depicted here before I mess it up.
Absolutely. So this is the Hale and Evers drainage model, and this is going to be showcasing our average expected response against the average petrophysical and geological and PVD data for the subject area in discussion today. So when we look at all of our internal data, we take averages, east to west across the subject area for petrophysics, PVT, and geological data, including making a correction for the SH max azimuth. Apply those inputs into the Hale and Evers drainage model. It yields out this drainage ellipse over time as depicted in the graphic in the table in the bottom right-hand side of the slide. What you will see is we are expecting heel-toe drainage impacts to occur no sooner than 10 years, and over the life of the well, we are expecting negligible impacts to offsetting DSUs. Again, I just want to reiterate this is an average, which we do believe is representative of the entire subject area in discussion today, but the supplemental slides that were previously brought up, and we will be presenting those here in a moment, do showcase more of a range. It showcases the east and the west and how the geological and petrophysical properties change and how that drainage model will also change. And I'll walk through that there, but you'll see very alignment with this model with those future slides here coming up in a few moments.
And I think I'm just going to skip E4 and then we're going to go back to it because that stays on this same topic.
Absolutely.
So we're going to go to, this is one of our supplemental exhibits. This exhibit was prepared and filed subsequent to the RIA and after you had an opportunity to talk with division staff, correct?
Yes, that is correct.
Okay, so if you can please describe what Exhibit E5 shows.
So this just showcases the Hale and Evers drainage model, but not focusing on our eastern side of the subject area today. So this will be 1 south, 3 west. So as noted by Matt on the geology side, there is a change in azimuth from the average, and from the west side, you're at roughly 154 degree SH max azimuth. It's a little bit different than a true almost north-south orientation. So accounting for that, as well as accounting for changes in petrophysical and other geological properties, and then putting those into the model to be more representative of the eastern side of the subject area today, it depicts this drainage ellipse over time, as shown in the graphic and in the table in the bottom right. Again, we are expecting no heel-toe drainage impacts to occur no sooner than 10 years, and over the life of the well, we are expecting negligible impacts to offsetting DSUs.
Okay, and then I'm going to move on to supplemental exhibit 6, which is the west side of the subject lands, correct?
Yes, that is correct. So again, you can kind of notice some of the petrophysical and geological and azimuth changes as we move from east to west across the subject area today. Now this now represents an expected drainage response from the Hill and Evers model for the western portion of the subject area today. And once again, just to reiterate, we are expecting no heel or toe drainage impacts to occur any sooner than 10 years and be negligible drainage impacts offsetting DSUs over the life of that well.
I'm going to go back to Exhibit E4, which is economics. If you can please describe this economic summary as between the 3 and 4 mile well recoveries.
Absolutely. So this is just highlighting the value of being able to drill longer laterals. I think it's been stated multiple times here and in previous exhibits that drilling longer laterals does allow for a more capitally efficient investment, and you get similar recoveries from on a per foot basis, and that is what's shown on the table in blue on the left. It shows you the estimated EURs and some economical values for 10, 15, and 20,000 foot laterals. And on the right side of that table in green represents the incremental value and EUR you get from being able to drill 15 and 20,000 laterals. These 15Ks and 20Ks do provide a lot of flexibility for us. Allows us to put more wells per pad, which minimizes surface impacts. And it also allows us to have more flexibility to tying into existing infrastructure, also minimizing surface impacts. But then there also is a capital component to this. We are forecasting 10 to 15% cost savings or reductions going from 10 to 20,000 feet, which allows for a more capitally efficient investment to be able to drill these longer laterals while still maximizing resource recovery.
Okay. Were exhibits E1 through E6 prepared by you or under your supervision, direction, and control?
Yes, that is correct.
And is it your expert opinion as a petroleum engineer that the relief sought in the RIA will protect correlative rights, prevent waste, maximize resource recovery, and minimize surface impacts?
Yes, that is correct.
I have no further questions for Mr. Whittington.
Mr. Haynes.
Thank you. Just a couple of quick comments, and then Spencer Nish with the division, petroleum engineer, would like to ask questions with the board's permission. If we could go to Exhibit E2, just for the division standpoint, there's no indication of what wells these were affecting. Are these wells that were near the subject lands in the area? Could you tell us a little bit more about where this occurred?
Yes, absolutely. So all these wells, the vertical wells as well as the horizontals, are all located within Section 20 of C4.
Okay. Then we go to E6. This is just a housekeeping thing. Our exhibit does not have a couple of the fields and inputs filled out. I'm not sure how that happened. Just want to make sure that the final exhibit that is given has all the information.
Okay.
Yes, I can show you mine. I can just show you on my screen right here. See, we're missing fraction.
Top right corner you're talking about.
Yeah.
Okay.
What do you have? I'm not sure how that happened.
Sorry. This one that I'm showing is the one that was attached to the motion, and so this is the exhibit that is on file in the record, but I'm going to double check that, and if it is not, I will replace it with this, but
All right.
I think that's right.
Okay. Yeah,
What's that? Oh, yours is missing that inputs as well? Okay.
All right, thank you. And now, I'll turn it over to Spencer.
I appreciate you breaking it on the east-west section. For my curiosity, mostly, when you calculated the draining models, like how many wells, like information did you use, and how is it determined for selecting them for the model?
So this model, it's depicting essentially like one fracture's drainage ellipse, because each fracture stage should have its own drainage ellipse. So this is going to be the ones that are going to be on the closest on either side of your section boundary. So in this particular case, that blue line represents the wellbore, and the rectangle would be the last perforated stage, which would then be your closest one near your.
So how many wells information did you use to average that out for it? if I wasn't clear, that's more
Sorry,
what I was trying to
sorry
ask.
about that. The exact number, so a lot of this was pulled from petrophysical data. I think we have our most recent update on petrophysical logs, and I can talk to our geo to confirm this, but I won't, 5 to 10, I can't remember the exact number, but it's in that range. And then we have core data in the area on at least 2 wells that was used to pull out these petrophysical data.
Thank you. That's all.
Okay, thank you. No further questions from the division.
So I'm curious, what do you estimate the actual life of the wells will be? You've given out 10 years, but how far beyond that will they continue to produce?
I think since there's no horizontal wells developed in this far north yet in the basin, can't give you a 100% answer on that one. I would predict out at least, I think most of our models run to 30 or 50 years, depending. Most of the time it comes to an economical limit at that point in time, which we expect to be somewhere within that 30 to 50 year range. I know these are unconventional basins, so a large portion of the volumes that are going to be produced will be produced within that 10 to 15 year window, but there is going to be a very long tail that goes out that has that 30 to 50 year range on it.
Okay, and as far as predictions go, I'd like your prediction on when you look at other more mature horizontal basins, do you see secondary and tertiary recovery starting to take place in horizontal wells?
In other basins of the lower 48, or predictions on for you went to specific?
Do you see that as being a factor that will possibly affect this basin?
I do. I think that's going to affect every unconventional basin across the globe, honestly, and it's just a matter of time when technology and capital play into the roles. Because, I mean, obviously, I think everybody in this room is aware that unconventional recovery factors are relatively low compared to conventional recovery factors. Think of like offshores, for example. So it's just a matter of time before enhanced oil recovery methodologies, whether that's surfactants, nanosurfactants, water floods, gas floods, name the technology, gets viable enough to enter into this basin and all the other basins. It's a matter of time. I know there is pilots going on in other basins, specifically the Midland Basin and the Delaware Basin, so those will be good trial runs to see how those work out. But eventually, yes, I do think enhanced oil recovery methodologies will come into play in this basin. It's just when will technology and time,
right.
When is that going to happen?
Thanks for the prediction.
I can give a summation, but we cannot forget Mr. McDonald as well. So I don't know if you want, why don't we let, well, no, I meant after my summation and his. I don't know if we want to, that's up to the board. But we can either do our things and then him, but I think it's probably better for him to go and then we do our things, because we can then comment on what he says. I don't know. If Mr. Haynes feels differently, I'm easy going.
Great. Do you want me to move on? You know, as indicated, when we received the request, the division reviewed it, and we had you know, more questions about the SH Max representation in the area, specifically because there are some underlying 1280s still remaining under the 139, 159 order. But based on the new data we were shown in the exhibits and the testimony, the division satisfied with the issues they had, and the division has no issue moving forward, and we have no objection to granting of the RAA.
Mr. Chair, your mic is muted.
Okay. Board, do you have any questions of the division? Okay, let's go to Mr. McDonald then, please.
Hello, my name's Ammon McDonald. First thing I want to clarify is my comment came in on my work email, so I want to be very clear by the fact that I am not here in any sort of official capacity for the Utah Geological Survey, Department of Natural Resources, or the state of Utah. I am simply a spokesman for my family, where we have mineral interests in this area. So when we got the RAA copies, I had a lot of my aunts and uncles, my mother as well, reach out. And their big concern is you know, this is all about orderly development and, you know, proper, or I guess consistent development might be the other concern. And with these all being laydowns from 640s all the way up to 2560s, the concern that my family has is, you know, they just come in and drill a 1920 and then they drill a 640, or they drill a 1920 again, or just almost kind of willy-nilly. And so that and how that affects our family and where that becomes a concern for us, we do realize that verticals are going away, and this is horizontals are the way of the future. And you know, we're not here to impede development or anything like that. Where it starts to affect our concerns is currently we're in negotiations with Crescent Energy, and Mr. Brooks did reach out to us almost immediately after our comment was filed. And so I'm pretty sure that we'll probably end up coming to an agreement. But what our concern would be is currently it's spaced at a 1280, and so we're negotiating from the standpoint that we have a 1280, and that's our interests have a certain percentage. And then as we try to negotiate a royalty rate, we proceed, and whether or not this is perceived or an actual leverage in our negotiating, if we get bumped into a 2560, our mineral interest in the wells drop down below 8%, whereas if it's a 640, we could be upwards somewhere of 25%. And so again, that's kind of our concern in that regard. So we just wanted to come before the board, make that comment, and I appreciate the board letting us express our concerns in that regard.
Okay, Mr. Chicken, any response?
Not for purposes of this request, because as Mr. McDonald has said, he's negotiating leasing, which is a private contract matter with my clients, and you know, we hope that they're able to come to a, you know, I hope that they're able to come to a mutually agreeable resolution of that. But no further comment on the specifics of that, because I too believe that companies are going to drill what are the most long producing economic wells, and overlapping spacing lets it really protects correlative rights, from the sense that nobody is ever cut out of what they're already in. So, you know, nothing we're doing here today, for example, is going to affect, you know, a family's percentage interest in a vertical well or a directional well. That's going to remain unchanged. And then they're going to, you know, have additional production from those larger DSUs, and they would share in all of that.
Okay. Mr. Haynes, any comments?
Sure. Yeah. You know, when the division receives these requests, we look at them in respect to the operators and their plans on how they want to develop these areas. We welcome comments from people like Mr. McDonald who look at these carefully and they decide, is this in their best interest? Because we don't know what their best interests are. I don't know any specifics about the situation, so I can't really comment on, you know, this or that. But we're trying to create a way where operators have a flexibility to develop their minerals and to produce the greatest resource that they are capable of. And yeah, if a mineral owner is out there and they feel like they're not being treated fairly or this isn't in their best interest, I always encourage them to come and speak up and be heard.
Okay. Thank you. Board, any questions of Mr. McDonald? Concerns? Okay, Mr. McDonald, thank you for coming in, and it's always great to have somebody come in from the front row seat watching these negotiations go on and hear your comments. Do you have any particular relief you want from the board at this point in time, or are we on notice here?
We just want to make a comment, you know, or kind of make the board cognizant of the fact that, you know, we are aware that you're not involved in contract negotiations, but decisions made by the board may potentially affect a negotiation position that a family maybe have as they're trying to negotiate with a company. So that's all we wanted to say.
We've got that awareness, but you're not asking for any particular relief, so
I mean, what the instead of having and I doubt this will happen, but instead of having this kind of willy-nilly lay downs, and we can drill a 640, 1920, a 2560, a 1280, if they just were to pick a specific unit, a drilling unit, and then our family would know what our position is as we go forward in negotiations. Like I said, we're currently negotiating on a 1280. If we become a 2560, we would like to know where we stand in that well.
Do you think you're getting enough information from?
Yeah, the company's been good. When I first made the comments, since then they've made our concerns known. They've reached out to us, and like I said, I'm sure that hopefully we don't get force pulled, but we'll have something in place before something like that happens.
Okay, thank you. Okay, back to you, Mr. Chicken.
I know folks probably coming up on lunch, and so I will make it short and say that Crescent Uinta, based on today's testimony and evidence and the division's position, requests the approval of its RAA as orally amended today. I would ask the board to please admit Exhibits L1 to L8, G1 to G6, E1 to E6, and R1 to R3 to the record. And thank you for your time today.
They're all admitted into evidence. Okay. Mr. Haynes, any closing comments?
No additional comments now.
Okay. Board, what do you want to do? Do you want to take a... Okay, are you guys, okay. Anyone make a motion? This is kind of a complex motion with all the amendments, so.
The amendments have been approved already.
Well, three, yeah. With the three amendments that were suggested.
Mr. Chair, I'll make a motion that we approve the RAA with the amended changes as requested.
Okay. It's been...
I second the motion.
Okay, it's been moved and seconded to approve the request for agency action with the three amendments as been verbally discussed. All those in favor say aye.
Aye.
Any opposed, say nay. It's unanimous. If you could please generate the order, Mr. Chicken.
I will do so.
Week or 10 days be good. We don't have any pressing travel or
I
anything
will
like that.
probably get it to Mr. Haynes on Friday
Okay, thank you very much.
or Monday. We'll see. Hopefully
All right,
Friday.
yeah, but
Hopefully Friday.
okay.
Thank you very much.
Thank you. Okay, Mr. Mayo, what's your thought here? Are you an hour-long, half-hour?
This one's uncontested, so.
Okay, so why don't we take like a 5-minute break and come back in here at 12:35 and we'll go forward, all right? Is that okay with you too, Mr. Haynes? Okay, should ask that first. All right, we're off the record for 5 minutes. Thank you, Matt. Welcome back to the board hearing. We're going to proceed with agenda item number 4. This is docket number 2026-028, cause number 130-51. In the matter of the request of agency action of SM Energy Company for an order, 1, vacating positions of the board's orders in causes number 139-140, 139-141, 139-153, and 130-31, insofar and only insofar as each order authorizes future development of the vacated stand-up units identified herein, and 2, amending the board's orders in causes number 139-140, 139-149, 139-153, and 600-04 to establish A, 3 1,280 acre DSUS, B, 2 2,560 acre DUBWD-SUS, C, 4 mile 2,560 acre DSUS, and D, 2 5,120 acre DUBWD-SUS, each for the production of oil, gas, and associated hydrocarbons from the lower Green River, Wasatch, Colton formations in sections 7 to 9, 16 to 21, and 28 to 33, Township 2 South, Range 2 West, and section 11 to 14, 25, 26, 35, and 36, Township 2 South, Range 3 West, USM in Duchesne County, Utah. Okay, let's take appearances.
Mitch Mayo of Lear & Lear PLLC on behalf of the petitioner, SM Energy Company.
Thank you.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Thank you, Mr. Haynes. Mr. Mayo, go ahead.
Mr. Chairman, I appreciate the board's attention to this and that reading of the uncomfortably lengthy caption of this matter. Although this is a really gigantic seeming pleading, this is really a fairly straightforward request that SM is here before today. The same development plan they have across their operated position currently. The only difference is they've got some new data they've incorporated, and it tells them that drilling these wells in a laydown orientation would be the better, more economic, more productive orientation. So that's the nutshell of what we're here to do today. There shouldn't be any new requests or anything that is new that you haven't approved for SM's development, other than these are being reoriented. So that's really the question we're addressing. With that brief introduction, I'm going to try and cut my introduction short to save the board time. I don't think anyone needs to hear me talk more, but I'm going to give you kind of a high level of what this case is in detail. First of all, with me today are SM in person, Rick Harris, who is the regional land manager for Utah for SM, Miss Katie Ross, who's the asset geology manager for Utah, and Brad Peterson, who's the Utah region asset manager for SM. Could we please have these witnesses sworn in at this time?
Please raise your right hands. Do you swear that the evidence you're about to produce is truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay.
Thank you.
Thank you all for coming today.
Mr. Board Chair, with permission from the board and approval from the division, each of these witnesses have been recognized as experts in their respective fields in prior causes, most recently in cause 130-49 in March. I just ask they be recognized again here.
Okay. Mr. Haynes, any issues?
No objection.
Board, any issues? Seeing none, they're approved.
Okay. Finally, to keep with past practice, I'll just reserve admission of exhibits to the end of my case in chief.
Okay.
As the board chair mentioned, this is involves an area of land that essentially straddles the range line between Township 2 South, Range 3 West, and Township 2 South, Range 2 West. The board has entered numerous spacing orders covering the subject lands over the years, and we're going to be modifying and vacating some of those. As board chair mentioned, the vacation of these orders that the board has established is only for future drilling. essentially, the wells that have been drilled under those orders, they will still operate under those orders. They will still be administered under those orders and paid under those orders, and they'll ultimately be plugged according to those orders. But any new drilling on the subject lands will be subject to this order and this order alone. Again, as mentioned, this is a request simply for 2-mile and 4-mile units. There are no 3-mile units that are being requested here today due to the currently established units and development plans, which we'll get into. Last couple housekeeping items. As of the date of filing this request, there are 99 wells producing or capable of producing on the subject lands, and SM operates every single one of those wells. The board has jurisdiction over this cause pursuant to 40-6-5 and 40-6-6 of the Utah Code, and notice was provided as required under Utah law to all parties with an interest in the subject lands. This notice was provided to their last known addresses of record, either as confirmed in the county recorder's office or as updated in SM's internal records. Finally, notice was published as appropriate and as requested, or as outlined in the law, and no one has filed a protest or objection to this matter of which SM is aware. Furthermore, the division filed a response and notice of non-opposition on the 10th of this month. Subject, of course, to the presentation of evidence here today. And with that, I still don't see, Matt, is there a way, I don't see my screen up on the big screens. Did I- Oh, I tried that here, but it didn't work, so.
Exit out of your presentation, the full screen part of it.
My apologies, board. One moment. Two on this side too, so I don't know if that helps. You were in that one before, so that one I guess is the new one.
Does anybody ever go back through all these things? And see if they're
Public?
No, like anybody go back through all of these things we're overruling. I guess it's their job to do that. I never go back through all that stuff.
as attorneys, we look at everything that's filing and submitted for orders and make sure it's consistent, not changed and accurate. That's what
Okay.
attorneys do.
Okay. All right.
Yay. I'm getting hungry. I need a snack. Hurry up, man.
That's perfect. Scroll. Okay. Board members, I appreciate that. There's a technical issue. I'm not sure what it is, but apparently this is going to be a little clunkier to navigate. So if I am on the wrong exhibit, give me a second, but we should get there. I can't really see what's going on my screen, so I'm mostly just watching the big TV monitors. I was just ready to start with Mr. Harris. Mr. Harris, thank you for joining us today. Would you begin by stating your name and business address for the record?
Yeah, my name is Richard Harris, or Rick Harris. Business address is 1700 Lincoln Street, Suite 3200, Denver, Colorado, 80203.
Okay. And what is your current position with SM and responsibilities?
I'm the regional land manager over our Utah assets.
And does that give you a supervisory role over the records and land associated information and the subject lands?
Yes.
Okay. Would you please confirm the corporate and bonding status for SM?
Yeah, SM is a Delaware corporation in good standing, having its principal place of business in Denver, Colorado. We fully bonded with all the necessary state, federal, tribal, and state agencies.
Okay. I'm going to go through there's a couple of introductory exhibits that the board has had time to look at and probably don't need to be hit on here, but I'm going to show you what's been marked as exhibits 3 through 10. Do you recognize these exhibits?
Yes.
And were each of them prepared by you or by SM personnel under your direction or supervision?
Yes.
Okay. I'm going to go back to number 3 and we'll start there. Quickly give the board, I mentioned that this is around the range line. Can you give them an orientation of where we are, approximate location?
For sure, yeah. So the lands that we're talking about today are highlighted in yellow there, and as you can see, they're in Township 2 South, Ranges 2 West, and Range 3 West. We're about 8 miles west of the city of Roosevelt, Utah.
So there's existing orders establishing units across the subject lands. Can you talk through the 2-mile development, what's there, what's going to remain, and what's going to be gone?
Sure. So this map here shows all the existing 1,280 acre units that we had formed, and as you can see in the strands there at the bottom, we'd like to vacate the stand-up units, not all of those, but most of those stand-up units, those 2 miles. In section 2, in Township 2 South, Range 2 West. Specifically, you want me to read the sections or
No.
just those kind of ones that are standing up there? And as you're going to hear from the technical team here in a little bit, we think that that's going to be better developed as lay-down units rather than stand-up units. And so we're asking to vacate those and turn them into new units.
Okay. And you said something I just want to clarify, not necessarily critical, but you said that we had established these 2-mile units that we had established. All of these 2-mile units were actually established by predecessors of yours, right?
That is correct.
With different data, different information, and different drilling results. when you
Yes.
established them. Okay.
And I should also say that we don't have another exhibit for 3-mile units, but there's also 3-mile units under that same footprint that we're also asking now to lay down rather than stand up.
So to sum for the board, this area here, the stand-up 2 and 3-mile units are going to be vacated going forward in this footprint because of their being turned as laydowns.
That is correct.
Okay. Exhibit 4. Talk through what you're asking the board to approve.
So these are the 3 new lay-down 1,280 acre 2-mile units that we'd like to request today.
Okay. And you're requesting corresponding section line WDSU units as well?
That is correct. We just the standard SM practice of drilling the section line wells. Those are the overlapping section line well units.
Okay. And can you confirm for the board on the left of this side in 2 South 3 West, all of those units are laydown oriented, is that correct?
That is correct.
And on the east of that line in 2 South 2 West, all of these units before today were stand-up oriented.
That is correct.
Okay. Let me go to, we'll look at 7 and 8 together.
Okay.
Can you talk through the 4 mile requests here?
Yeah, so Exhibit 7 shows all the approved existing 4 mile units that we've requested in front of the board previously. And then Exhibit 8 shows the highlighted ones that we're asking for today.
So it's clear, I think, from this you can see that SM is moving toward longer well development as kind of a matter of course.
That is correct.
Okay. Let's go to Exhibits 9 and 10, the last ones, what we're asking for here today. Can you talk about the 4 mile sectional units that you're asking?
Yeah, this is the exact same as just the corresponding section line, lease line wells, that units that for the 4 mile development.
Okay.
So 9 was the existing, and then the 10 shows the requested.
So if this request is approved today, eyeballing about 50% of this area is set up for 4 mile development.
That is correct.
Okay. With that, I don't really have any other questions. I did want to ask you about notice real quick before we go. Who did you notice? How did you notice them? What was accomplished? That kind of stuff.
So this one was a little bit easier as we have horizontal development across these units right now. So they're really new title opinions. We've updated title as needed, obviously, with our ongoing revenue decks, et cetera. But we ordered title where needed and used our existing internal records.
Okay. And did you mail notice to all relevant state, tribal, and federal authorities?
We did.
Okay. Have you seen what's been filed as a certificate of mailing in this cause?
Yes.
And have you reviewed it?
Yes.
Does that list constitute the full list of parties that received notice in this?
It does.
Okay. There were no formal protests or oppositions, which I've already mentioned. Did you receive any informal protests? Anyone reach out and say, hey, Rick, I have concerns about this, and it just never materialized?
No protests, but we did get, as when we get on all these, we get a handful of calls, 5 to 10, of people just asking what they're doing and do they need to respond. And then once you explain that it's future development and we're laying down, they get pretty happy and they're excited about the development.
Okay. Well, with that, in consideration of Exhibits 3 through 10, is it your expert testimony that this is the best way to protect correlative rights, maximize resource recovery, and minimize waste?
I do.
Okay. I have no further questions for Mr. Harris pending the division or board. And if you'd like, I can go through all 3 witnesses and you can ask them all questions, whatever the board's preference is.
Okay. Mr. Haynes, anything?
Yeah, I have a question for Mr. Harris. If we could go back to Exhibit 4. Just want to get a clarification. So we have this, and we have the little part down the bottom says 2 and 3 mile stand-up units to be vacated. In the REA, I don't believe that the stand-ups furthest to the right, the 1280s, are being vacated. Is that correct?
We only put those on this exhibit because the overlapping lease line.
Okay, but those specific 1280s, those are staying, right?
They are staying, yes.
That's all I needed. Yeah, no further questions. Thank you.
Important clarification. Thanks.
Okay, board, any questions? Seeing none, proceed.
Thank you. Mr. Harris, stay close, but you can sit down. And next will be Ms. Katie Ross. Would you please state your name and confirm your business address for the record?
Yes, Katie Ross. I work for SM Energy. I'm the Geoscience Asset Manager for Utah. And our address is 1700 Lincoln Street, Denver, Colorado, 80203.
Okay. And as the asset geology manager, do you exercise a supervisory role over the geoscience related records that are at issue in the subject lands and presented and discussed here today?
Yes, I do.
Okay. I'd like to remind you all that she will be testifying as an expert in geology and geoscience. Ms. Ross, I'm going to turn to your exhibits and do similar with Mr. Harris. Exhibits 11, 12, 13, and 14. Do you recognize these exhibits?
I do.
And was each of them prepared by you or by SM personnel under your direction or supervision?
Yes, sir.
Okay. Let's start with Exhibit 11. They see this often. Tell them what they need to know about this, if you wouldn't mind.
Yeah, this is a type log, similar to that you'll have seen before. Lake Fork Ranch is a really key pilot along this subject lands, and you'll see this again throughout a couple of slides as I tie into some other vertical wells, gamma ray, resistivity, and then you see the breakout at the top there of the Uinta Upper Green River, Lower Green River, and Wasatch and Flagstaff formations. And then along in the gray lines, you see some of our internal stratigraphy that we refer to at SM to kind of break up our deep cube, which is Wasatch 2 and down, that W2, and then lower cube, which says CP long point to W2, and then anything upper cube at our company we refer to Castle Peak, that long point marker, and shallower from there.
Okay, so let me make sure I'm showing them if you can.
Yeah.
So upper cube, you would say
Correct.
is CP long and shallower. So
Mhm.
up from CP long to the W2,
Lower
you consider
cube.
lower cube.
Mhm.
And then W2 and deeper.
Right. Internally, we refer to that as the deep cube.
There's not really standardized names for any of these.
You could talk to many different operators, and they have different feelings and opinions.
Turning to Exhibit 12.
Yeah, so again, there's that Lake Fork Ranch I was just speaking about. That's on this cross section in the southwest, A to A prime. And then we've got the Mirren and then the Linmar. And that Linmar is a pilot or vertical that's in the heart of the subject lands. And again, just showing that from a rock character standpoint, very similar across this acreage. I'd say the one thing that is slightly different as we move to the east is there is a slight thinning in the Douglas Creek, but that's only about 200 feet from the west to the east. But overall, the rocks along this transect are very similar, consistent, and that's how we characterize it at SM.
Okay, thank you for that. Now this is different. It looks similar but different, and it's pretty noisy. Will you walk through kind of high level what each of these three parts is and what they tell together?
Absolutely. So this is something new that we haven't shown before, but this is the exact same cross section that we had in the previous slide. Just cut off one of the tracks to simplify, but
So
it's the same wells.
You've got this and added information to it.
Correct. And then you see a plethora of dots on those, and the color coordination of those dots represents the cubes I was originally talking about. The green dots are potential upper cube targets that we discuss and target depending on where we are in the asset. The black dots are the lower cube targets that we cuss and discuss and target based on economics. And that blue dot down there is a potential deep cube target that needs a lot more work, but it's here for illustrative purposes. But the main takeaway is that top left table. You'll see an MDC to CP. That's a mid-Doug Creek to Castle Peak. So that is showing from, if you go back to the right, Mitch, that lower green dot. Oh, I'm sorry. On the same slide,
sorry.
The lowest green dot to the black dot. You have a separation of over 600 feet and still over 450 feet as you move west to east. And then another major point here I would point out is the Wasatch 3 to a potential Wasatch 2. That would be the tightest if we ever were someday to come in and drill underneath existing development. The tightest it would get based in this area is still above 200 feet. And then in the bottom left of this slide, we do have a development where we have done this before. We've drilled on top of existing lower cube development and our top gun acreage. I don't know if you recall on the Tetris shape that you saw in the beginning of the presentation. The reason you have that gap there is because we have drilled upper cube wells above lower cube wells before. And that's just an example of what was done there.
Okay. So I think I guess the takeaway from this relative to what the board is really grappling with in this request is there sufficient space if we change the orientation of these units physically between the well bores to ensure that protection? And it sounds like there's, in the most likely targeted area, there's 400 to 600 feet of physical vertical separation.
This minimizes waste for sure.
Perfect. Anything else from this slide that we should talk about before I move on?
I think that's it. I think I covered it.
Okay. 14.
Yeah, so I've got 2 maps here. I'll start with the top right map. That's what we discussed in March, and we did mention that there was a shift of where we're interpreting our SH max rotation to occur. Credit to our predecessors. They used the data that they had in hand, XCL. We have more data, and that's the map that you see larger and to the left there. There's more arrows on there, and it's a conglomeration of drilling-induced fractures from image log, microseismic trends, and frac response trends. So we have started completing wells that were stand-ups and that 2 south, 2 west, and have observed certain frac interactions, and that confirms that the SH max is more in a north-south direction, and that the most effective drilling orientation and completion orientation we could do is lay down to make sure that we are maximizing our resource and minimizing waste. So that's the data that our predecessors did not have that we now have at our disposal, and we constantly integrate that and update that and do the best as we can to be good stewards of our acreage.
Okay. So essentially, you know, the board's heard about this in the past. It's typically been, you know, kind of largely understood that the transition, if you will, between stand-ups and laydowns kind of occurred right around this range line.
Right.
That's
where
different.
it was previously put, and now we're saying it needs to be moved slightly to the east. And a lot of that too is that 1 south, 2 west, that data points that we have up there, XCL did not have that at their disposal either that we have now.
Okay. So the new data plus some new drilling tests that you've done on your results lead you to this conclusion. Anything else on this slide that we should point out before we turn you over to questioning?
No, just happy to have new data and to share it with y'all.
Yeah. Any last question for you? In your expert opinion, do you believe this request is fair and is the best way to maximize resource recovery, minimize waste, and protect correlative rights?
Yeah, I think we're doing the best we can to develop the acreage as best as we can.
Okay. Thank you for that. No further questions. I'll turn her over to the division and board.
Division, any questions of Ms. Ross?
Division has no questions, Ms. Ross.
Okay, board. Can we go back to 13 just a second?
Of course.
Of these green dots and black dots and blue dots, can you tell us generally which ones are actual wells, which ones are these all proposed?
No, that's a really good question. It varies depending on which DSU you're in based on the geology. This would be what I would consider an overstacked example. For the most part, if you look at the right cross-section, we'd only do 3 of those dots and maybe 4 of those black dots, 4 to 5, depending on
3
where
of the green and 4 or 5 of these.
Yes.
You'd only do, I'm sorry, say that again.
So it depends on where you are in the acreage for which of those dots you would drill. You don't drill all of them consistently across the board.
So all of this, what we're looking right there is proposed?
Yes, yes, correct.
Aspirational, if you would. Yeah,
yes,
okay,
that's
gotcha.
a great way to put it.
Okay. Okay, thank you.
Or maybe just, you know, this is showing where things can fit.
Yeah. Okay, but they're not actual well bores that are being depicted here.
It's not ubiquitous across the acreage where it's always going to be those spots.
Okay,
Yeah.
thank you.
Yeah.
But it seems like the lower on the, like you said, below the Douglas Creek, there's pretty a unit there that really isn't very productive before you get to that further down.
That 600
Yeah,
foot space.
I think that's where we tend to leave a gap in our development program going forward. And you can see that even in that Top Gun example to the left, showing that what we call gun barrels. There's that gap there between the green dots and the black dots to illustrate that.
And can you clarify, Ms. Ross, maybe you don't know, but is this gun barrel the actual in the Top Gun?
That is the actual what we did.
So to answer your question, Mr. Walker, this is the...
That's an example. Yeah.
And this actual, as Ms. Ross mentioned...
it's the gap in the Tetris piece.
Yeah, it's this little unit right here.
Okay. Has anybody done the deep cube yet?
We have a test in the deep cube, and we're still studying what to do with that.
Okay. All right. Thank you. Great.
Yeah.
Any other questions? Okay. Go ahead and proceed, Mr. Mayo.
With that, I'll move on to my last witness, Mr. Peterson. When you get situated, sir, will you state your name and confirm your business address for the record?
Yeah, it's Brad Peterson, and it's 1700 Lincoln Street, Suite 3200, Denver, Colorado, 80203.
Okay. And what is your position and generally your job responsibilities?
Yeah, I'm the Utah Asset Manager. I'm responsible for development and optimization, integration of the geoscience team, engineering, and completions to, work to most optimally develop the acreage.
Okay. Obviously, that puts you in a supervisory position with respect to these lands as well.
Yes.
Okay. Mr. Peterson will be testifying as an expert in reservoir engineering and planning. I'm going to show you quickly what I did for the other two witnesses. Exhibits 15 through 21. Do you recognize these exhibits?
Yes.
And was each prepared by you or SM personnel under your direction or supervision?
Yes.
Okay. Starting with Exhibit 15, can you quickly kind of point out from each of these what you want the board to know?
Yeah, so about 9-10 months ago, we had developed some of the acreage. We call it first row sports, but right next to where we go from laydowns to stand-ups. We started looking at the performance in a lot more detail, and what we were seeing is the results from some of those wells weren't as good as what we were hoping. And then, as a result of that, I looked at our old, they're called Butcher Butte wells, and so those are the oldest Axia wells, and so I took a little bit of a time to look at how do the stand-up versus the laydowns perform. Specifically, as a result of, right around that where we drilled stand-ups versus laydowns. A couple other engineers in my group looked at in detail the development from Field of Dreams, Happy Gilmore, Major League, Tropic Thunder, and Unbroken. So again, laydowns next to stand-ups. And looked at that performance, and from those.
Just to interrupt, those names mean nothing to you all, but they're units set up on either side of this range line.
Yeah, they're just. It's easier to. It's really I would say the 4 sections east of where we transition to the stand-ups, and then the two developments, 2-section developments down there to
down
try to really
about here, right?
Yeah, right in there. Okay. To really try to look at it, normalize, for closeology, and then what should we see from azimuths. Further on to that work, the team worked through multivariate analysis, and so we have these multivariate analysis tools, which I just call MVA for short. And really what we try to do is we put all the geological models, all the completions design, how we completed all the wells, kind of well densities, and, optimized kind of development, or all the different things that come into development planning are in there. So, inside that, pressure gradients, azimuth's one of them. And so inside those, we built a couple different looks at the inside the MVA with looking at the data, and really what we had come to look at in the initial look that I did on the Butcher Butte wells, saw somewhere in that 8 to 12% if we moved 2 miles more east of potential benefit. The look that the additional team did showed similar differences in in those fully developed DSUs, somewhere in that 8 to 16%. And then what you can see on that slide is from this more robust look and more detailed look with the MVA model, the difference between the stand-ups and the laydowns roughly got into that same delta difference in performance. So really seeing somewhere in that, call it 8 to 10% difference if we move over these two, east to 2 more sections to develop, that we should be able to drain the acreage better. The other thing that it allows us to do is, drill longer laterals, so we're able to, also have less disturbance for the acreage, and then we're working to integrate the development of these laydowns into existing pads that are out there to help really reduce the cost, and we'd be able to put these new wells either drilling above or below into existing facilities. So that's really, some of the bigger drivers for, there's a performance difference that we did see. And then we integrated with kind of our updated geomaps that have the difference in the azimuths, showing that, this data actually is lining up with, some of the things that we've seen on the performance side.
Okay. So if I can boil it down, you did a bunch of looking back at past results. You analyzed data, and what you determined is you'll get about 8% more production if you lay these down than you would if you left them the way they are.
Yes, we used multiple different tools, methodologies, and data sources, and all pointed to about that 8% benefit. This next slide...
This isn't unheard of, right?
Yeah, I mean, I think that, as you continue to learn and you continue to get more data, then we just got to keep looking at ways to optimize it. This next slide really shows, some of the other examples where, the initial wells have changed orientation to develop the rest of the development. So there's a lot of examples in the Bakken and Eagle Ford, and if you look closely at these pictures, you can see, wells oriented over the top or above or below, existing initial wells. Also, the far kind of right Uinta example shows where just to the south, things have changed as the development matured, and more information's come into play to adjust how wells are oriented to really optimize development drainage.
Okay. And talk about these two, if you would, kind of together.
Yeah, so I wanted to also give a little bit of an update on how the 15,000 foot and 20,000 foot programs are going. So we're really, really far along on the 15K wells, and we even have more wells online after I've made this slide, a couple weeks ago. So we're continuing to turn on, the 15,000 foot wells, but really, 45 well program, really, very, very successful, as well as the 20,000 foot program, getting those 14 wells, they're drilled. We anticipate turning, most of those wells will be on by the end of the year with them starting to come on October, November timeframe. And, we'll start seeing some results there. But overall, pretty great execution that we saw from drilling and getting these wells, the 15K wells on today. The next slide really goes over a summary of kind of what we're thinking on the development plans here. So as we're requesting some just 2 miles laydowns and some 4 mile laydowns. There are a couple areas where we have overlapping 2 miles and 4 miles, and we would plan to drill there are some existing wells on the western, right in there, existing, but we're looking to maybe come above those in a 4 mile, and then we drill the same zone, kind of inner development plan at 2 miles. This is going to require a lot of work to re-space this, both on the surface side and working through all the facility and anti-collision. What you can see and shaded there in a kind of a light gray is an area where we're really going to have to work through a lot of anti-collision design work. You can see a lot of the well heels kind of going through there. This is one thing that was brought up during initial discussion with you guys. So we have been looking at it. We're looking at first take point, first take point, as well as pipe design, as well as kind of how far we need to kind of be offset to that in our designs. You can see the timing. Really our internal planning. We're going to really start working hard on that, getting this all worked out in the July timeframe. Drilling will be kind of that March through June timeframe with the different rigs. But since all the developments interconnect, we're kind of using the same timelines. And I think really too, due to the success we've had on the 4 mile program, it does allow and facilitate us to drill, these 4 mile wells and reorientate and really optimize the development at that time.
But probably one of the main reasons you've been so successful in your drilling program is because you've taken the time to plan them out really well ahead of time.
Yeah, either you plan to succeed or you don't plan and you fail. So like we do spend a lot of time on the upfront side trying to plan and make sure everything's successful for all the stakeholders involved.
Okay. Real quick before we let you go, the last 3 slides I just want to talk about collectively. They've seen these a bunch, but can you talk about the setbacks and the appropriateness here?
Yeah, so we've shown kind of some similar slides in the past. This first slide really shows kind of some porosity maps here for both the upper and the lower cube. In the middle, you can see the viscosities, and then also a permeability kind of estimate. So really from the porosity, we have core data that gets us to some perm estimates, and that's what we use in the Hale and Everest calculations. And then the bottom slide, or the bottom, is really the PVT data that we have, so you can see the different viscosities for the upper cubes as well as the lower cube. And then really just put these into the Hale and Everest calculations. I would say the one this area has been approved previously for the 100 foot setbacks. The one thing that is a little bit different, and Katie already talked about a little bit, is vertically we're going to be over 200 feet, offset. Our closest drainage that's going at the other azimuth, or at the other direction. And I would say from everything that I've seen in the industry, vertical drainage is usually less than lateral drainage. So tying into these Hale and Everest calculations, we feel that over 200 foot offset that is going to be the tightest that we see on future laydowns versus current stand-ups. We don't anticipate any vertical drainage of note that would be a concern to have to think through. So this is the upper cube example, and then this is the lower cube example.
And you don't have any concerns with the 100 foot setback 10 years out for upper cube or lower cube in this new orientation?
No, I don't.
Okay. With that, I don't have any further questions for Mr. Peterson in the interest of brevity. So if the division or board would like to go deeper into these, please feel free.
Just briefly, could you go to Exhibit 18? Yeah, just a little bit more clarification. We talked about anti-collision issue in that shaded area. Just looking at this, the bottom 2 units, where would the well pads be for these wells, and what angle are you coming in at?
Yeah, so the pad would be on the opposite end of the arrows, and so if I start from the north, our current plan, and we're still working, surface use agreements, and then also some of the facility and pad optimization work and how we expand. So right now, this is the current plan going, so west to east there. On the second 2 miler, it would be west to east, and then on the bottom 2, currently planned to go from east to west. And then in the middle, so we would, if in the bottom two sections, we'll have some 2 milers alternating with 4 milers, because there's already, on the western sections, there's already some 2 milers in the Douglas Creek. So we're developing around them.
So I see, it looks like you have some well pads in place, but on the bottom 2, are you going from an existing well pad, or are you going to create?
Yeah, so from to the south there,
yep,
we'll be kicking, we're working to expand that pad and then kick up to the north.
Okay.
And then the opposite thing coming from the north one, where we'll be on that northern pad, but kicking south.
Okay.
You're going to try and use and expand existing.
Yeah.
Yeah. All right.
And again, we're still trying to work through some things there, but that's the current plans, and we're just trying to utilize the existing facility infrastructure and pads as much as we can to minimize disturbance.
All right. Thank you. No further questions from the division.
Okay. Board, do you have any questions? Can we go back real quick to 15 and 16? Oh, okay. Just want to make sure. Okay, because I hadn't checked those off. I must have been distracted along the way there. Okay. Good. Thank you. You know, it's one of your predecessors, Josh. I can't remember Josh's last name, but
Josh Sigler, yeah.
Sigler, yeah.
The geology professor he used to
Yeah, he
joke
was
about, yeah.
starting all this stuff. So I'm glad to see you guys didn't drop that and keeping it going. So it's I've read a bunch of his papers. And where'd he go?
I think anecdotally, I think he started his own thing, and they're looking for an oil and gas asset to bring in. So,
well, give my best to Josh if you ever run across him. Okay, thank you.
Sure. Thank you.
Okay, anything else then?
No, it's probably, if there's no further questions, it's probably appropriate for me to move for admission of exhibits 1 through 21.
So admitted. Okay.
Yep. No objections.
Okay.
And in summation, I believe we've met all the statutory and regulatory requirements, and that this request is the best current plan for development of the lands, and I'd ask you to approve it.
Okay. Did you ask to admit Exhibit 2? Or,
I did.
Okay, all right.
Exhibit 2 is
that's the
spacing
some
orders.
places.
I'm not
Yeah.
sure.
Okay.
And maybe when the board redoes its rules, we may not even be required to submit the spacing orders anymore as exhibits, but to the extent they're exhibits, yes. Let's admit them.
Seems like a good rule too. Okay, thanks.
Yeah.
All right. Okay, done. Division.
Thank you. As indicated, the division filed a notice of non-opposition in regards to this request. Prior to that, the division had met with SM, discussed their proposal. Then they submitted the RAA. We reviewed the RAA and the exhibits. We still have no objections to it, and so after hearing the testimony today, the division has no objections to the granting of this request. Thank you.
Thank you. Board, do we have any questions of the division? Okay, and just to make sure, is there any public comment from any parties? And Matt, is there anybody online that would make a public comment?
No, there is not.
Okay, good. Hearing none. Okay, division, or board, sorry, do we need to consider this or further? I'll entertain a motion.
I'll make the motion that we approve the request for agency action as presented.
Okay, is there a second? Second. Okay, all those in favor say aye.
Aye.
Any opposed, say nay. Good. Okay.
Just kidding.
Okay. Let's do that again. All those in favor say aye. Aye. Any opposed, say nay. None heard? Okay. All right, so the motion is unanimous. If you could go ahead and take care of that.
I'm happy to do that, and we'll try and get it filed by Monday for sure.
Yeah, and okay.
As soon as we can. Yeah.
Okay, are there any more issues? Anything from the outside? Matt, anybody online?
No, we are good to go.
Okay, I'll entertain a motion to adjourn.
Nay.
I move we adjourn.
Okay, all those in favor of adjourning, say aye.
Aye.
Okay, we are adjourned. Thank you very much. Off the record.
Kill a creature